Oh,
We'll bring you on in just a second.
okay.
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now doing commentary on the case. Dati mihi Anglican por verbis Latino.
Literally not true.
Is that correct?
I didn't ask you to interrupt me. Oh, for crumb's sake.
All right, welcome to the Court of Public Opinion. I am the Recovery Addict. Great to have you all here this morning. And it's more than all of y'all there. I've got someone here with me as well on the phone. Before I let her speak, let's turn the music down just a little bit. Before I let her speak, let me tell you how this phone call started. And it went something like this. It said, I picked up the phone, I said, hello, and I heard something like, forgive me, RA, for I have sinned. I've come for confession. It's been like 2 weeks since my last call, or something like that. I don't remember exactly how it started, but Kayla Newell is on the phone with us. Kayla, how are you doing this morning?
I'm okay. I sound like a man.
You've got allergies, and it's understandable.
I do.
Well,
yes. But please forgive me.
Yes.
My father's fault, for I have sinned. It has been months since my last confession to you.
Months since the last infraction. We do remember it. They say forgive and forget. We forgot to forget. But Kayla, what have you done?
I just want to live my best 80-year-old retired woman life and want a concrete goose in my 36-year-old age.
I'm sorry. Did you say concrete goose?
Yes. And I want to put it in my lawn, and I want to give it a great name. And I'm looking at, hold on, I have a list.
You guys,
hang
on. If you're not on our Facebook group, you're missing out on this entire story, and you're wondering what's going on. A concrete goose did enter chat this morning on Facebook. I guess last night, right? I forget when it was.
Yes, last night. Yes, and apparently it's a hit. Let's see. Oh, where is it? Well, I know one of them I put was greeners, just straight greeners. Mm-hmm. But I have Goosewing Gacy, Lady Featherface, BTK, Beak Torture, K, exclamation point, LL.
You were
Dennis.
The greeters, don't take this in any way as a negative thing, but you've suggested a bunch of murderous names for your concrete goose.
Yes.
Okay.
Yes.
And greeners.
But Dennis, the concrete, and greeners. Bob the Honkinator. But greeners, and then somebody added Jim McIntyre. But
we couldn't find
I could always just leave greeners and be like, who's that? That's greeners. He watches over the dead.
You're gonna
just leave it like that.
You're gonna have to use a little sign in front of him, whatever the name is.
Oh,
whatever you choose.
Yeah,
the goose needs a sign, a placard.
It does. It does need a placard.
Okay.
It does, and I'm very creative with that.
I have to ask you this: are you willing to abide by the terms of the poll? Meaning that if we choose a name, is that the name you're going to go with? Okay.
150% and 3/4.
All right.
Yes.
You guys know what to do. Go vote for the name of your choice, and Kayla will plant your name in her yard in front of a concrete goose.
Yes. Yes. But if Greeners comes up with a better name for Greeners, that's fine too. But if it's not, like Greeners,
we're thinking like a Sweeney Todd type name, right? Like,
yes.
we've got something dark and mysterious. Maybe we used to, like back in the day, we used to have really good names for serial killers. When did we go away from that? When did we just start using their given name as if that was good enough for a serial killer? Why don't we have like, I mean, we had like BTK and stuff like that.
Right.
But now it's just like
not anymore.
Jim McIntyre or you know, whatever the name may be.
Ooh, how about Greener's Dexter Goose again?
Jack the Gooser.
Greener's the Waddler.
We have a picture. You sent us a picture of the goose? I
don't have the goose yet.
I have a picture of the goose in Mod Chat. Yep. Mm-hmm.
I don't see a picture.
Well, that's because you don't have Mod Chat. Hold, please.
But if it's a potential goose that I'm gonna have, I need the picture.
Oh, we're gonna.
Because what if I want to decorate it like that?
You don't. Just for the record. Okay, everyone stop texting me for just a minute. I'm not going to put this on the big screen. There's no way. I'm not. You guys, I don't want you guys to have that quality of an image of this, but this is the... now we just broke chat. Not sure why. This is... Let's go here. This is a picture of the goose. Is that... Are we talking about the right one?
Let me look. Hold on. I'm looking. I haven't signed into the live yet. I just knew it was about time for you to go live, so I started calling.
Okay, well, I can't hold this up forever. People are taking screenshots.
I know.
You're going to have to rewind. Sorry, my arm got tired.
Okay, that's fine.
My arm got tired.
That's fine. I'll rewind.
Okay.
That's fine.
Hold, please. I just lost chat for a minute. Restore chat. Pop out chat.
I'll rewind. Not a big deal.
Live chat. There we go. And now we put it back on screen. Let's switch to camera 4. Okay, there we go. Well, take a gander at that. Yeah, that's awful, Greeners. That was absolutely awful. Now she needs to. All right, Kayla, here's what I'm going to say. I'm going to send people over to Facebook, and they're going to vote.
Okay.
And when you're done, we need the sign and a picture of the goose. The real picture, not the one Greeners sent me.
That's fine.
Okay.
That's fine.
All right.
I'm hoping to have it by Sunday for Mother's Day. That's all I ask for.
Where does one get a concrete goose? I mean, is there a
I'm in
concretegoose.com? Or?
Well, yes, and apparently there's a bunch of people that hoard them and sell them.
Is it part of a set? Is it do you have the whole Old MacDonald Had a Farm set? And the goose is just
but they do have Highland cows.
A concrete Highland cow?
Yeah, but you can't decorate it.
Good grief. That must make
and I want to put wigs and things on this, so and knives. I have a whole
As
plan.
One does. Yeah.
Yes. I can't put this one at the CAC though, so I'll have to get a nicer one for the CAC. So.
Wow.
The Advocacy Center. Yeah.
Kayla, I appreciate you confessing your sins. Give me a minute, see if we can forgive this one or not. It's gonna take some time, honestly. We have to deal with some things, right? So, Kayla, thanks for this start this morning. Happy Thursday to you.
You too.
We'll see you. Bye.
Bye.
I sometimes don't know what I'm doing here. All right, welcome. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict, and that's what happened in my morning. How was your morning? It's great. It's great to be here with y'all. We have to say a big welcome to Irish Leone. Irish Leone, you're first in chat. You know what that means? That means we're going to punish you for your promptness. Everything IP related worldwide is your responsibility. I have 2 concrete lions in my house. I do. My front porch, I have those 2 lions. I have painted them with glow-in-the-dark paint, red glow-in-the-dark paint around their mouths and their eyes. So on a dark night, See, like if the power goes out on the streetlights after having a super bright flash of lightning right in my ear, you have to have the right series of events have to take place for this to work. You have to have like lightning strike right in front of the lions, so we get like a blindingly bright light, and then power has to go out everywhere. If you were to run out right then and look at them, they would glow faintly. The paint was not as glow in the dark as I had hoped, but I do have 2 golden. They're painted gold, and then stone lions. Do you feel like a kindergarten teacher? A little bit, but I know at the end of the day, I get to give you all your homework back, and you have to go pin it on your fridge. So I get to rinse my hands of this, and the goose is not going in my yard. I mean, I'm just saying. All right, that's exactly how our ancestors wanted our lions. Yes. Josh says, I had no part in this, just for the record. Thank you. Welcome. What did we forget to do? Birthdays? Yes, birthdays. Let's Greeners, thank you very much for getting us back on track. We are, in fact, on a schedule here. So let's sing to the wonderful people who have birthdays to celebrate today. Jan, not short for January, by the way. Jan, Jules 30, Lacey, Nick Rowe, Sue, Thomas, and Tom. All right. It's a lot of names. It's alphabetical. Nick, I can't get your numbers in there. I'd mess that up. But everybody else, I think we've got it. We're gonna sing to these wonderful people. And wherever you are, if it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. All right, it's birthday time. Happy birthday to you. Happy birthday to you. Happy birthday, dear Jan, Jules 30, Lacey, Nick, Rose, Sue, Thomas, and Tom. Happy birthday to you. That was close. Had there been one more name, we would not have got it in. But I'm a professional, and I got it done. Jan, Jules 30, Lacey, Nick Rowe, Sue, Thomas, and Tom, happy birthday. There are many wonderful days. Today is your special day. And I realize there are a million places you could have been and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn that joy back to you, make your day just a little more special, or begin by helping yourself to free pancakes. At Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Whew. There we go. And now we can just sit back and watch the dancers do their thing while everyone else votes for Greeners on the Facebook poll. Or the saying of their choice, the name of their choice. I voted for Green. I voted for Greeners, I admit. I think Facebook shows you that, so I can own up. It's not entirely a secret ballot. But no sponsors yet. No sponsors. No. Which means I get to choose what I get to say every day. I like that. All right. Happy birthday. It has to be Greeners. Greeners the goose. I mean, look at this logo. Look at this face. Look at that. What are we voting for? We're naming a goose, a concrete goose that Kayla's going to put in her front yard. You already out of me. Yeah, I figure either get in front of it or get behind it. One way. Drum solo. Please show the towel. Oh man. Made me mess up the drums. There we go. All right, birthday song is finished. Show the towel. This violates the principles of what stays in mod chat. What happens in mod chat stays in mod chat. The towel. Okay, the beach towel. Merch idea. Greeners, I'm going to have to just implement a rule that if you send a merch idea in mod chat to mod chat on the channel, that instantly grants me exclusive rights without any royalty payments to actually produce said item and sell it for my own personal profit and gain. Are you cool with that? Is that I think that's a fair deal? Is that That's something you could sign off on. All right, let's show the towel here really quickly. This is the towel version. If you want said goose with the with the Recovery Addict mouse pad underneath, take a gander at this. Nothing like that would ruin your beach vacation quite the same. That's just scary. That's just not right, Greeners. That's not right. All right. Nunes, I'll take a look there in just a minute of your Discord trip, or your trip on Discord. Let's see. Give them at least $10. I've got a call. It's probably Greeners signing off on the deal.
Call from
Kayla. No.
Oh, it's better. Kayla, welcome back. How are you doing?
If it gets Greener's name, I get a towel.
Okay, but if you get
Just
the towel,
saying.
I get the merch rights to the towel.
That's fine, but I get the towel for free.
Okay, I see where this is going. Well, Greeners would have to leave a donation to cover the cost of making the towel.
As long as the donation goes to Sylvia's Child Advocacy Center.
Okay. These are heavy negotiations. I normally have an agent do these. I say that, but I've never had an agent, so I don't know what to do here.
I'm really good at getting money for this center. So.
You raised like thousands of dollars, right?
12,000.
That's awesome. That is really cool.
I'll send you pictures later. It's pretty
Sloth
cool.
Life
Yeah.
says that towel would look fab on my cruise. No one would steal your chair. I can tell you that much.
See? Nobody would goose your gander.
Okay. Help me do this. We're going to make the towel. Greeners, can you send that to me in a clean format, like no sand, no distortion? Get it nice and we'll make the towel. Nobody wants that towel. Everyone's like, "Can I just get the logo?" Who said that? Can I get one that just says Recovery Addict?
Everybody wants the towel. Who wouldn't want Greener's the Goose towel?
I'd have that as a mouse pad, to be honest. Can we use boxers? A different conversation entirely. Lynn Taylor, the poll is on the Facebook page. It's over on the Facebook page.
Yeah. And you have to scroll down a little bit.
Legally Blonde says, "Have her call me. I can negotiate this for you."
Okay. I'll hang up. And they can do the negotiation.
Mary, I don't know what happened. Something's in the water this morning. Maybe the stars aligned or misaligned or something. But
the planets, they just didn't. Yeah.
Yeah. We're going to delete this live stream when it's done anyway. So, thank you. Kayla, thank you very much. We'll be in touch. All right. Bye. Bye. It's not even Monday. We don't have an excuse even. I'm not sure what is going on. We came to watch court. We've got Judge Simpson's doing some things. Judge Dad's doing some things. We're trying to get to a hearing about the scheduling for our case up in Ohio for Caleb Flynn, whose name I remembered by myself this morning. We've got some stuff going on, and then we're talking about a goose, an RA towel from my new pool. I think we'll do this. If I can find a place that can make our towels for us, that we're already associated with, like one of the companies we already use, I'd do it. It's really hard to set up a new one, and
Because he's the guy.
we'll see if we can make a towel. Like seeing Judge Dad. Let's take a look at our options first. Oh, wait for it. X-Effects. Where's my settings? Go back. Hope that's not it. It's connected to the switcher. 4.215. Somebody remember 4.215 for me just for a minute. While I turn off my Wi-Fi. That's great. I'll turn it back on. Hold, please. I need to fix this so we can make everything work. 4.215 and 4.61. IP addresses we have to figure out. Why is it not working? Close that. Sorry, this is very important. Let's just jump to Judge Dad while we wait for just a second, then we'll get it fixed, okay? Just 1 second.
You're ruining your life. What are you doing?
You want to make arrangements before that day with somebody as far as Friday court, or?
No, you can take the packet. Why don't you go over there, unless you have to run out of here, we can do that. They'll give you a packet for him to review, and he can meet with the sobriety court probation officer now if he'd like, and they can at least explain the ins and outs of it, okay? And we'll see at 11 on the 21st, but I want you on a SoberLink device by the end of the day. Is his parents with him?
No, his parents are not here.
Where are they?
There.
They know about this?
Yes.
Good luck. Stay out of trouble, man. All right, good luck. Don't go anywhere. I'm going to take that. Julie Therese Gagne, 26G306741.
Hello, Joe Murray Duncan, appearing on behalf of the defendant, Julie Gagne, who's to my right.
Good morning, ma'am. Your name?
Julie Gagne.
All right,
Somebody's
so
got a
this is
loop
going to be a
going.
plea operating while impaired. They're going to dismiss the OWI, true?
Yes.
Is that what you want to do, ma'am? Is that what you want to do, is plead guilty to operating while impaired with the understanding that the OWI will be dismissed?
Yeah.
If you plead guilty to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs are all those, 4 points, license suspension or revocation in accordance with your record in your vehicle could be, or might have to be immobilized depending upon your record. Do you understand that? And did you sign, read, and understand the advice of rights?
Yeah.
If you plead guilty, you will be giving up all those rights and we will not have a trial. Do you understand that? All right. Any questions before I go on? To the charge operating while visibly impaired, ma'am, how do you wish to plead? On March 20 of 26 at 11:07 p.m., were you operating a motor vehicle on Jefferson near Gibraltar, in Gibraltar?
Yes.
And prior to that, did you drink alcohol? And if so, what did you drink and how much?
Yes, I had 2 Jack and Cokes and a shot.
Shot of what?
Jack Daniels.
Peppermint shot.
Okay, was it a single shot?
Snaps.
Was your ability to operate that motor vehicle impaired because of the alcohol consumption? And in what way?
I was told that I swerved. I was at a light, and when I turned, I was told I swerved.
Do you think you swerved?
Yeah, because I know because my car had to autocorrect it.
Okay, do you think you swerved at least in part because of your alcohol consumption?
Yes.
Counsel, this says a 0.146 on the blood draw. Do you stipulate that was accurate for purposes of the plea?
Yes, Judge.
Are you on probation or parole, ma'am?
No.
Anybody forced you to plead guilty?
No.
Ever been in trouble at all before?
No.
I'll accept the plea, dismiss the OWI. She had some case in 07, an ordinance violation, but it was dismissed. That's it. So I'll refer you. Right. So I'll refer you for a screening and assessment, okay? And you're going to go down the home. You're going to get your notice, and then you come back for sentence. You want to do this on the 21st to Mr.
Yes.
Yeah, I'll tell you what. We'll do this at 11 too, okay?
So you want her to go down and get a notice?
She's going to go down and get a notice, then you're going over to probation where you'll fill out a questionnaire and be interviewed, okay? And then come back on May 21st at 11.
Thank you.
Thank you.
Have a great day. And by the way, everybody, this is not my rule. If you guys would consider filling out those public satisfaction surveys, the Supreme Court wants us to do that. I'd appreciate it.
Can I get one of those for the judge?
Where is Brendan James Toe? 260-646-409. Is this kid going to learn anything here if he dismisses this?
None of the victim is here. The parents.
Where's the victim at?
She's seated in the bank.
Come on up here.
There's 2 cases, Your Honor, so there's a global resolution.
Oh.
You know, since we were here yesterday, his grandmother just passed away, so the family's got to go, and it's been just a rough week. Ma'am, would you step forward? You step back. Edward Zelenak, the defendant, is present.
Good morning, ma'am.
Good morning.
Your name?
Jill Frederick.
Okay. Why don't you go right over there, if you would, to the that is a microphone, believe it or not. And I have Brendan James 1226BT 646409 and 26B 149414. Your name?
Brandon James Code.
All right. And his parents are with him.
Yes, they are.
And the victim is not seeking restitution, it says on 414. Are you the victim on the Brownstown case, ma'am, or the Trenton case?
Trenton case, brother.
All right. Are you seeking restitution of any kind?
Just for the records to be completed.
It's been arranged already.
All right. I need to put it on record, though. Call him Mr. Bologna. So he's going to plead to the turfing charge under height on the Brownstown case. And that is, if you plead guilty here, these are the possible penalties: up to 500 fines, 90 days jail, costs, or all those. This would be taken under HIDA, and I believe, and I haven't had a turfing case in years, I think if there's a straight up plea that
a turfing case,
you'd lose your license.
No, this shouldn't go anywhere.
Well, I know it won't under HIDA, but I'm just saying if there was a straight up plea, you would lose your license. Do you understand that?
Yes, sir.
So if you don't comply with probation, the conviction's going to be entered and you're going to lose your license. Do you understand that?
Yes, sir.
Did he go get Mr. Bologna? 249. So if you plead to that one, the prosecutor is also going to move to dismiss the Trenton case of turping. Do you understand that?
Yes, sir.
What is?
Did you sign, read, and understand an advice and rights form here today?
You signed it yesterday. You signed the advice parties.
I still need to sign one today. You're presumed innocent. They have to prove you guilty beyond a reasonable.
I'll give one here to sign what you're talking.
Okay. Did somebody get a hold of Mr.
Just called him.
Okay. And Ms. Frederick, I'm sorry. You live on, just tell me the street. I'm sorry, which one?
Third.
Third. Okay. Mr. Bologna, your name?
Anthony Bologna, Your Honor.
I want to make sure everything's covered here. Is there some kind of risk? I understand what you're doing. He's pleading on the Brownstown case. Victim not seeking restitution. It's going to be under HIDA. Based on that, this other case, the Trenton case, is going to be dismissed. I just want to make sure that the restitution is going to be taken care of.
My understanding to be taken care of, it was presented with a company that was providing services.
But if the case is dismissed, I lose jurisdiction is the problem.
I understand, Your Honor.
Well, we can come back. They can charge him again, Judge, and there'd be hell to pay them.
Well, no, not if it's part of another plea agreement.
Well,
Did you get a quote?
I did, yes.
How much is the quote for?
$676.
I think there's a work order too that you might have already, right?
Wait a second. Are the parents going to pay the $676?
Yes, they are. Are they already paid? Have you paid the company already?
Your Honor.
What's your name, sir?
Chris Cove.
Okay.
Brother's dad. The company that I reached out to actually takes care of her loan as well for sterilizing and care. He is just trying to fit in the schedule.
Have you paid them yet?
I offered to pay a deposit. He said he wanted to wait until the work was done because it could be in time of materials, but that's the 676 was his maximum.
Max.
Yes.
But see, I can't dismiss this, guys, without that being taken care of. Now, if he wants to cut a check to her today, 676, then I can feel comfortable dismissing.
This is lawn related.
You're going to pay the 676 today? Can you do that? Because I can't dismiss a case and still have restitution hanging over, and I don't think it's. You're good with that?
Yeah.
And what's your name, ma'am?
Michelle Cove.
I appreciate you guys coming a lot more. Your son and I are going to have a conversation. So that's what'll happen. Do you have a checkbook here?
I do.
So you can write her the check, write out to herself, and then we're going to cover this. Is that acceptable to everybody, Mr. Zolnick?
Works for me, Judge.
Is that acceptable, Mr. Bologna?
Judge, I have no idea what's going on.
Ma'am. All right, that's what we'll do. So you can write that check to her. I will dismiss this as soon as they hand her the check. I'm going to take the plea on the other turfing. And have you signed that advice of rights now, young man?
Just like that.
If you plead guilty, you'll be giving up all those rights on that advice of rights, and we're not going to have a trial. Do you understand that?
Yes, sir.
What do you do to be guilty
You understand
of
everything
turfing?
that's going on?
Yes, sir.
You seem like a nice kid. Why in the world would you be doing this? We're going to have a conversation. To the charge of turfing, how do you plead?
Guilty.
On the Brownstown case, March 29, 26, were you at 19256 Dawnshire Drive? What did you do?
Because I was very upset.
Upset with what?
But we were bad and breakup and.
With who? With who?
Her dog.
Broke up with
So it's collateral damage.
Well, wait a minute. Wait a minute.
You did?
19256 Dawnshire, your daughter doesn't live there, or does she?
No, it's another friend.
That's another friend.
Well, wait a minute.
That's
I'm just taking the plea on the Brownstown case. Okay? So why did you drive over the lawn at 19256 Dawnshire?
Driving on the lawn.
Who did you know that lived there?
a friend that's dating your daughter.
Oh, the new boyfriend.
So you intentionally drove over the lawn?
Yes, sir.
Did you do donuts on the lawn?
Are you on probation or parole?
No, sir.
Anybody forced you to plead guilty?
No, sir.
But you guys broke up before they started dating, right?
My understanding, yes.
Well, no, I'm asking you. You and her daughter broke up before your best friend started dating her, right?
How about if I ask the question? Your best friend you found out started dating
Yes,
her,
sir.
and you got upset and you made marks on everybody.
But were you broken up with her daughter at that time?
Yes, sir.
You got to be more mature than that.
Yes, sir. I
right?
understand.
All right. Anybody force you to plead guilty?
No, sir.
Are you on probation or parole?
Sir.
I'll accept the plea. Ms. Frederick, I want to listen to what you have to say. Anything? I know that you're you've got the check.
They're doing it right.
Okay.
Sorry.
Go ahead and write that check, and then we'll talk. Do you want to tell me anything, ma'am?
Only if you need clarification on anything.
I'll be happy to listen to anything you have to say.
I'm good, thank you.
Okay. What are you doing with your life right now?
Yeah, operator.
The what?
Operator G.
Okay.
324.
Good.
Sir.
And
the
you
union.
are going to be 20 in December?
Yes, sir.
I don't need a pre-sentence report, Mr. Zellner.
No, we're fine. He has done well, I presume, because he went straight into the union. He's got a pension and health care and a better suit than most lawyers here have today.
Better than one I brought. Yeah. I didn't even bring my coat in today. I put it on the couch. Anyway.
Nothing else to add. Your Honor, it speaks for itself. These are sad incidents for affairs of the heart that have been, whose brains don't form as quickly as women tend to do crazy things.
I know. Where'd you go to high school?
Friend.
And so you're going to stay out of here, right?
Yes, sir.
Did you ever have a conversation with them, ma'am? With his parents after this?
They had reached out to me the day afterwards,
To say what?
to apologize and ask if they could make things better.
That's what I would have expected parents to do. And I want to commend you guys for doing that, because a lot of parents would not have done. A lot of parents would have looked the other way. So it means a lot to me, frankly, that the parents came with you, Mr. Toth. So that's going to help you. You don't want to embarrass your family.
No, I did not.
I feel like making you go read a poem.
To read Shakespeare, Judge.
No. I want you to Google this when you get home tonight. You don't have to do it tonight. Talk to your mom and dad about it.
Sure.
Just Google your name poem. Do that. Now, it's a little gender related, but you can look at that with your mother too. You follow me? It's your name. Read that poem. Okay?
I'm ordering you to read a poem.
All right. I'm not going to be that tough on him. I mean, what he did was silly. But you know what? We've all done silly things. I did silly things. We all did silly things. But I want you to understand something. I do not condone this. You got to use your brains. This kind of thing affects your future. You follow me?
Yes, sir. I completely agree.
You don't want to affect your future. So I'm taking the plea under HIDA. Mr. Zelnick, I think I already asked you, but if you have something else, I'll listen to you.
Yeah.
Do you have anything else, young man?
No, sir.
All right, let me just write this up. How do you feel about this? Because you are a victim. And I want to make sure that you're satisfied too. I don't want to poo-hoo this. I don't think there's anything to poo-hoo. By the same token, kids make mistakes. And to a 19, 20-year-old kid to find out his best friend started dating his girlfriend could have been handled like 10,000% better. But what are you asking me to do? Anything?
I'm good, thank you.
All right. I have to place you on probation, so I'm going to, for 6 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. Now, I'm not going to know if you do this, but see, your parents have shown a real interest in you. I think that's phenomenal. They did what I would have done. They did exactly what I would have done. And they're here. And that means a lot. Check. So I want you to serve 1 day of community service by June the 30th. And I want you to be on our court work program for 1 day. And that's going to cost you $35. Your parents are going to make sure you read the poem, Your Name.
Dad's writing it down.
See, my father was buried 40 years ago today, so I'm a little more sentimental than usual. So I actually went back and read that. 100 fines, 100 costs. 75 victims' rights, $50 justice. 120 in probation fees, 35 in attorney fees.
No, I'll take.
I'm sorry, 35.
I'll take the.
No. I'm sorry, 35 in court work program fees. That's $480.
$35.
I want him to pay this, not you, folks. So if you need time, I don't have a problem. And they're going to make sure that you read that. I don't need you to tell probation or prove anything to probation. They're going to make sure you read that poem. Can you pay this today, or do you need time?
Bill Trades can take care of it.
And you've received your payment, right, ma'am? The 626?
676.
676. I'm sorry. And you're satisfied?
Yes.
So I'm dismissing 260-646-409. Prosecutor indicated on the Brownstown case, victim was not seeking restitution. We're going to give you a review hearing date. You don't want this on your record. Give me a date if you would, Heather.
Okay, Judge, that will be November, well, let's see. About November 4th.
November 4th at 8:30. You don't need to show up, Mr. Zelnick, unless he hasn't complied. Folks, thank you very much for coming. I appreciate it. I don't want to keep people waiting. I need a 5-minute recess. Thank you. Stay seated, please.
Judge is tearing up. He just went with his all his living family members and visited the grave of his father, who'd passed away 40 years ago. So as he's talking to this young man whose parents are there supporting him in court for a stupid thing he did, he tells him to read the Your Name poem, which is a poem about where your name came from and how you get your name from your parents. That gift to you is something you get to live with and then get to pass it on to your children. And it's what you do with your name and what you've made of it before you pass it on is what it was. So Judge teared up a little bit there, talking about being sentimental during that. So YouTube names are not from your parents. No, they're not.
No, I see you, Noah. You're fine. James Bucker, can you hear me?
Yeah, she's on North. Oh, that's why she had to hold on. Yeah. Remember, she also being on her same.
Hello?
Hello?
Yes, James. Does your camera work?
Yes.
I'm just going to watch the
I'll
camera.
email you a copy of it. Yeah, if I get a little down just to it disorderly, under advisement, and we're good.
All right, there you are. All right, you have your pretrial today. I'll get you in a breakout room and an attorney will be with you shortly. Just sit tight. We're very busy today with the attorneys are, okay?
Okay.
Any specific notes if he comes, this is one, yeah, okay, yeah, I'll let him know.
In the meantime, do a standing order, just a simple one, text it to me.
Okay, all right, thanks. All right, very good to see you.
Mr. Boker, do you see that invite to the breakout room?
You.
Give me a second here. Trying to do 6 things at once. I'm doing none of them very well. So, Spring Stores does not sell towels. I have to figure out who else we sell through. Spread Shop. Okay. See if Spread Shop will let me make a towel. In the meantime, Judge Simpson just stopped his feed. Oops. Let's see, we've got... Josh sent us a little something something. Just have to try to find it. Give me a second. Hour and 45 ago on Goggins. Okay, give us a second. We've got one from Josh, who never fails to deliver quality. Let's see. There we go. Hour and 45 ago, roughly.
Is that what it is?
Yes, sir.
How much is your disability check?
$2,190.
Is it before this, Josh?
Okay. Yeah, and my understanding at this point, we'll just order your court-appointed attorney.
I'll hand over everything I have today in my DC.
Okay.
I think it's before this. I can't see anything in chat. Like my chat disconnected. So, let's see.
Specific notes that myself and my staff have written.
What notes were you asking?
Okay, we're going back to the beginning of this one. I think this is it.
Helps, Your Honor.
Okay.
Still there. Okay, here we go. Give it a minute to start. Who's the poet of your name? I think it's unknown. I'm looking for Mr. Leslie, but I don't know what he looks like.
Gosh, I guess, boy, poor Robin's running back for it. We might do Rummer if we can. I got the file. I guess any Vance and whoever our prosecutor is.
Josh, if you can just tell me how far back it is. You said an hour 45. That's where I am.
Strip matter.
Authors Edgar A. Guest.
Oh, the other, yeah. Okay.
We're here.
All right.
We're here. We can start
Ready
now.
to proceed with Joshua Bremer. And you're here for.
Oh, yeah.
All right. Okay. Okay, make sure I got it. Who I got for what? Thank you, Mr. Bremer.
Bremer? Yes, sir.
I'm getting ready to handle your matter. This is actually, I guess it's, not sure which one it is. It's a motion, first of all, I guess, to either withdraw or have you dismissed, Mr. Carter?
Yeah, it was my motion to withdraw, Your Honor. I do believe that the court showed me some documentation that he sent in earlier. I didn't get notice of that, but I did get a chance to review it. I guess I have no objection to whatever he has found.
Okay. Mr. Bremer, is that, I did get a chance to read the paperwork that you sent in. The first part is you wanted, I guess, get a new attorney. Is that right?
I'm having a really hard time. It's kind of like muffling a little bit. Let me move out of this room and go into another room. See if that helps, Your Honor.
Okay.
Okay.
Is that better?
Yes, sir.
Okay. So this is, I guess the first thing is that this is Mr. Carter's motion to withdraw from the case, I guess.
Yeah, that would be correct, Your Honor. I filed this motion to withdraw. I believe that we reached a bit of an impasse. I did bring a copy of the police report, and also he did give me an exhibit that he brought to my office as well. I have it here that I could pass to whoever gets the case after I do. I believe that he wants to file motions that I don't quite agree with, and we reached a point right now where he should get his either a different attorney to handle this up.
Okay. Mr. Rummer, and just, I guess, just a nutshell, does that make sense? Is that right? You two are kind of in an impasse how to handle this case?
No, Your Honor. It was a strategy aspect, Your Honor. I asked Attorney Carter for the strategy and how we were going to move forward in the case, and he refused to tell me how the case was going to proceed, and that was where the mix-up came in. And I asked him to do several requests from different areas, and also that was refused. And I asked for a strategy of notes. There was a list of notes that were written out, and those were refused. I mean, they were offered to me, and then Attorney Carter refused them after that. And I'm not sure why he would refuse me the strategy and the notes for the case so I can make a formed decisions. The reason why we had an issue with how to move forward is because I couldn't get the strategy and I couldn't get the notes and I couldn't make an informed decision myself. And so it wasn't a misunderstanding. It was a refusal of Attorney Carter's. There was actually 11 attempts of me trying to ask for the notes and the strategy, and it was refused every single time, Your Honor.
Okay, so what notes were you asking for?
There was no strategy to be one, Your Honor. The notes of the strategy. As far as what I learned, that every a lawyer has a strategy, and they're supposed to present that to their client. And when I'm sorry, go ahead.
Did he talk to you about how to handle the case? I mean,
no, sir. I asked him over and over again for how is the case going to work? How is it going to be handled? A strategy, Your Honor. And he refused. And I recorded the whole conversation, and he knew I was recording, and he still refused. And then at the very end, I said, we're not going to get off this phone until you agree to it. And he said, okay. And so I hung the phone up. I go, that's good enough. And then he still refused to send it to me in the mail after that.
When we say no, so this is what he's
referring to. I have a copy of the police reports that I've given him and a copy of an exhibit that he...
Objection, Your Honor. I had to go all the way to Michigan to get that, Your Honor.
Mr. Trevor, hold on. Don't interrupt him, but I'll get you a chance to talk again. Just let me hear from
So
you.
he has a copy of all of the police reports and all of the videos. I think he literally wants the specific notes that myself and my staff have written in a copy of the notes.
What are your personal?
My personal notes, work product.
Mr. Trevor, that's kind of.
No, Your Honor. They were not personal notes. They were strategy notes that his office assistant offered them to me. And then he came back and said, no, I'm not giving those to you. Those are my notes. And I'm like, they're Amy's notes, and she offered them to me. He's like, well, I'll talk to her about that. And it's all on recording, Your Honor.
All right, it sounds like there's a breakdown one way or the other. It sounds like there's either miscommunication, something.
I already filed with the State Bar of Michigan, Your Honor, for charges against Attorney Carter.
Yeah.
That's how severe this is.
He wants off, then gets himself. All right, so I'll grant the motion to have Mr. Carter taken off the case. He grant motion to withdraw.
Sounds good.
Yeah. And then what we need to do is set it for a new date. I'll order. Mr. Remmer, are you hiring your own attorney now? What are you doing? What do you want to do?
No, sir. No, sir, because it was Attorney Carter's decision to withdraw from me. I'm still needing assistance from the courts in Michigan.
Okay, so do you have a source of income at all? I see you're on disability of some sort.
Yes, sir. I'm 100% disabled. No way of making any kind of money.
So you get a disability check once a month? Is that what it is?
Yes, sir.
How much is your disability check?
$2,190.
Okay. And my understanding at this point, we'll just order a new court-appointed attorney.
I'll hand over everything I have to the NIBC.
Okay. So new court-appointed attorney, Mr. Remmer, and we'll set a new pre-trial date, I guess. What we do it that way? Set a pre-trial for June 8th. And then we'll do that on Zoom too to help you out because you're out there, okay?
Thank you, sir. I appreciate that.
June 8th at 8:30, and we'll get you a chance to talk to the new attorney on that date, okay?
Your Honor, one more thing I'd like to bring up. The video from the TSA shows me getting dragged by the police officers, and the phone, my AI phone, says that should be a dismissal right in itself. And between that and the refusal of the TSA report from Attorney Carter, I'd like to make sure that was a part of the record.
Okay, so that's what you're going to have to talk to your attorney about, okay? Because I can't get in the middle.
Yes, sir.
Unless I got a formal motion of some sort, okay?
Sounds like you don't need a lawyer. You need your phone.
With your new attorney, and then we'll address those issues when it comes up formally for me, okay?
And maybe a competency exam.
Copy that, Your Honor.
All right, other than that, we'll send out a new notice for June 8th at 8:30 and have a new attorney for you, okay?
Thank you, sir. I appreciate you.
Well, I appreciate you being on there. Thanks. Bye.
Let's go to a little quieter court, shall we? Oh, my goodness. My AI phone tells me that I should be... Judge, let me send you the screenshot from ChatGPT. Tell you how to do your job. All right. Hello, sir. How are you doing? You ready for court? Oh, there's two of you. Welcome. Stuart Cohen's here as well. Who's our first guy? John Farquharson. Fark U. Harson. That's it. John Fark U. Harson is his name, and Stuart Cohen. Love nailing the pronunciations on these. But this is another... I'm pretty sure that's how they say it, wherever he's from. I butchered that. No. That's like the native tongue. I even said it with the right accent. This is another one from Josh. Let's see. Oh, we've got Judge Krause is here as well.
Good
Judge,
morning.
Good morning. Good to see you.
Good morning, Your Honor.
Okay, I have a number of matters on this calendar. We're going to just run through the calendar, see who's here for what, and then we'll figure out what order we're taking up the individual matters in. Position 1, Boy Wonder versus Brickcell Investment Group. Do I have anyone here on behalf of either of those parties?
Crickets.
Good morning, Your Honor. This is Bradley Koblitz here for Brickcell and Miller.
Okay. Welcome, Bradley.
Sir, have you had any contact from anyone that was going to be representing the plaintiff or the third-party defendants?
One of the third-party co-defendants, yes, but no, we have not heard anything from Boy Wonder's side since the announcement.
Okay, and what about the reason I asked about the co-defendants is I think at least one of them, the argument was allegedly coextensive with Boy Wonder, right? Was it Mr. Johnson?
She said Boy Wonder.
I believe so. I remember the attorney's name was Miss Monica, and I'm blanking on her last name. I apologize for that.
And had you had any contact recently with anyone since Mr. Mzikewe is no longer in the case?
My understanding is that we've had contact with Monica, and I cannot remember her last name. I'm sorry for that. I'm looking through my notes.
That's okay.
But we have not heard from Boy Wonder or the third-party co-defendant that's in default.
Who is Boy Wonder?
And that really is the issue that I'm trying to figure out is I anticipated that perhaps no one would appear on behalf of those entities. And so I'm going to want you to workshop while I'm getting through some of these other matters what that might mean. This is a peremptory hearing, and failure to appear can result in a dismissal of your claim. But in this case, I believe your client has some counter or third-party claims, and so I need you to let me know what that means from your perspective in terms of what relief your client might seek if, in fact, no one appears today.
Sure, I think
there's a
give
Brazilian
some
flag
quickly.
behind him.
Sure.
My understanding, at least, is that the third-party co-defendant that we've been in contact with, that there was some discussion of a mutual resolution if the plaintiff never made an appearance or never started pushing this case. And we think that that is in the very near future if the plaintiff continues to be absent.
Okay. It would need to be in the very near future because this is actually a pretrial conference and the trial is set for the week of May the 25th, which just in case that scared anybody, yes, I know that is Memorial Day. And I don't plan to be here and I don't plan to have anybody else be here that day. Jurors would murder me if I had said I was going to bring them to court on Memorial Day. That's just the Monday of that week, and that's how we bookmark it. So I think the day would be the 26th, which is a Tuesday. If, in fact, any of these cases actually need to go out for a jury trial. Of course, if it's not a jury trial, then the court can accommodate it a little more fluidly, kind of anytime it wants. So anything else? Mr. Koblitz, what I'd like for you to do is stay on the call for a bit because I'm not at 9:05 just going to say, oh, well, they're not here. I'll see if someone appears by the time I'm getting done with the calendar, and then we can figure out what to do from there, okay?
All right, absolutely, Your Honor. I'll be here.
Thank you, sir.
Thank
Cohen versus Just Add Product.
Just Add
Good morning,
Product.
Your Honor. Stuart Cohen appearing pro se.
Okay, and I see Mr. Farquharson is also here. So, Mr. Cohen, you may have seen in this case that the court entered an order explaining to Mr. Farquharson that in a court of record, which the Superior Court is, a corporate entity has to be represented by a lawyer, can't be represented by a person. Did you see that order that I entered?
I did, Your Honor.
Okay. So one concern I have, Mr. Cohen, is that although you brought suit as Stuart Cohen, doing business as SBC Enterprises, my review of Georgia's corporate records indicates that SBC Enterprises is in fact a corporate entity. Is that correct, sir?
It is correct, Your Honor. It's an LLC.
Okay. And so the problem with that, Mr. Cohen, is that means that you have the same problem that I was explaining to Mr. Farquharson previously, which is that just as he can't answer on behalf of Just Add Product, you can't assert a claim on behalf of SBC Enterprises because it's got to be done with a lawyer.
Your Honor, I was just made aware of the pretrial conference 13 days ago.
Okay.
And I've interviewed 3 firms and we'll have attorney on board by the end of next week.
Okay. So in that case, what I am going to do, Mr. Farquharson, did you have any questions about that issue and what I've just raised with Mr. Cohen?
No, Your Honor, no questions. I understand.
Okay. What I'm going to do is this matter is still technically set. I believe my records indicate it was set as a non-jury trial. Mr. Cohen, what I'm going to do is we will look for it to be set for that week of the 26th of May. And then what I'm going to need you to do is, if you are talking to any attorneys regarding this matter, you'll need to let them know that the case is set for trial. I believe it is currently set for a non-jury trial. So we could, as I said, my review of this case indicated that it's fairly straightforward. Hopefully wouldn't take more than maybe a day or so to handle, especially if it's a non-jury trial. But what I'll need, Mr. Cohen, for you to make sure is that any attorney that you retain, that you let them know that they'll need to file an entry of appearance as soon as possible. And then, and what would happen is we would send out a notice for you guys of when to appear for your trial. And then if you have a lawyer, then we will try to proceed. And if you don't have a lawyer, Mr. Cohen, then at some point the court will have no choice but to dismiss the case, because you can't represent yourself anymore. You can't represent your corporate entity any more than Mr. Farquharson can.
I understand, Your Honor.
Okay. And I apologize, sir. Am I pronouncing your name, sir, correctly?
My name, yes, sir. Yes, Honor.
I was meant Mr. Cohen. I'm pretty sure I had right, but Mr. Farquharson, is that correct? Or even close?
That is actually spot on.
Ah, okay. Gold star for me.
That was so close.
Gentlemen, thank you very much. Do you have any other questions for me about the process or procedure or what will happen next?
No, ma'am.
Mr. Farquharson?
Well, the one thing the question I did have is I noticed I apologize for wasting the court's time with the MSJ, because I realized somehow the package of the evidence didn't make it through the e-filing. So I did contact the clerk's office. They're looking into it. But I just wanted to make note that, I apologize for submitting that, and somehow the procedural errors that I made the evidentiary package didn't join up with the motion.
I appreciate it, but I can assure you, sir, I have had lawyers make the same error, right? The e-filing system is less than perfect, and sometimes people try to submit things that don't get accepted and they don't know it. And so I understand the error, and we will deal with the substance of the case moving forward if and when Mr. Cohen retains counsel on behalf of SBC Enterprises. And other than that, I will see you guys a little later this month. Okay?
Thank you, Your Honor.
Thank you both. Have a good day. Amlac versus Patrick Smith. Mr. Wardlaw, how are you, sir?
Good morning, Your Honor. Attorney Wardlaw for the plaintiff. I haven't had a chance to speak with the defendant or really nail this case down. It seems to be a smaller case. We're asking for $12,000. I would like to speak with him or see a little bit more about this case before. We're ready. It'll be a short trial. I think it's only plaintiff and defendant.
Yeah, thank you, Mr. Wardlaw. And of course, your client had the same issue that he managed to fix, which is to retain counsel. I think he initially tried to bring this case on his own. This is a peremptory hearing. Do we have anyone here on behalf of Mr. Smith? So, Mr. Wardlaw, what would happen if no one appears today? I would be essentially asking you the same thing you heard me asking Mr. Koblitz a moment ago, which is, what would you have the court do if no one appears in terms of any remedy? If you are actively in contact with Mr. Smith and trying to work it out, then my question is, where is he today? But you can tell me what you want me to do.
So much progress, he didn't show up to court.
We'll be asking for a default and for the damages we requested in the complaint.
Are the damages, I have not looked at your complaint, sir. Are the damages liquidated or unliquidated?
Unliquidated damages, yeah.
Okay, that's better. I don't do liquidated damages.
So, Mr. Wardlaw, I'm going to ask you again to sort of hang out for a few minutes, and I will see if anyone appears on behalf of Mr. Smith. Have you had any contact with Mr. Smith or anyone on his behalf?
No, Your Honor.
Okay. And once we get towards a little closer to 9:30, I will make a determination that that individual has not appeared, and then we'll figure out what to do from there. Okay, sir?
Yes, Your Honor.
Thank you, Mr. Wardlaw. And Mr. Freehoff, is Miss Smart, has she been able to get logged in? I know she was having some trouble.
Hi, Judge. I have sent both her and Mr. Melhorn the link with the subject title, Zoom link for pretrial conference. And that was before you even started up this Zoom hearing. So they should have it by now. And I don't know where either of them are at.
Okay, thank you. Mr. Llewellyn and Mr. Peacock, there you are. Sorry, I've got some people on my screen.
Sorry, Judge, I'll
this
move.
is Collins versus Strack. Mr. Llewellyn, have you gamed out your technology today?
Those are some headphones.
I have a new computer.
Oh no, the new computer was the problem last time.
Oh yeah, no, it was a recent computer that blew up. They only last 5 years. What had happened is the motherboard went in the midst of my argument. So I got a new one. We called Dell, and it
mid-argument motherboard.
That is unfortunate, but
explosion.
we're all here now, and hopefully your technology is going to hold you in good stead.
Right.
This was the matter that I had expected would take the more of my time this morning, although so far y'all had been pretty, efficient in the presentations before we had that technical glitch. So I'm just making sure you guys are both here. I'm going to put a pin in y'all and then get to the rest of my calendar and come back to you in just a moment, okay?
I'm going to put a pin in y'all.
Thank you. And then Pine Tree versus Loca Holdings. Hi, Ms. Claire and Mr. Denhart.
Here for plaintiff.
Denhart,
Yes, sir.
how are you?
Good. How are you, Honor?
Doing fine. Okay. So I got your filing, and I know you probably think I'm being overly difficult, and I don't mean to be, but here's what I was actually looking for. I don't actually think that you can withdraw an order that you were ordered, a motion that you were ordered to file by the court. And I also don't think you can withdraw a motion for default judgment when someone is in default, which means you agree that I'm not seeking a default judgment. But the issue we have here is that the record seems to indicate that there is a default. And I know that Ms. Claire's position, and it seems like you're not objecting to it, is that service wasn't good. It wasn't sufficient. And so what I was actually expecting y'all to do is just file something saying that we agree service was insufficient. But that doesn't have to happen. I see that Ms. Claire's client has filed an answer now. And so I feel like I can let this go, even though I do tend to be kind of pedantic about it, and I do apologize.
Pedantic is a great word for today.
But I wanted to let y'all know sort of what my thought process was in terms of I wasn't trying to be overly difficult. It is that default is automatic if there is, in fact, sufficient service. And I understand that was the disputed issue here. Correct, Ms. Claire?
Yes, and we did file an answer by special appearance. So plaintiff would still be required to properly serve the entity Local Holdings.
Right. And that's actually the main issue. That's the main reason that I sort of keep holding on this issue is that although
she's just dismissing everybody. I can't find the funny one here on this one.
to get into litigation in this case, and 6
But
months from now,
let's jump to Judge Simpson.
have a whole fight about waiver and everything else.
Ooh. Got a hot mic. Hello, Jules. Welcome.
That's good. Did I do great saying my name?
You did great. Just waiting for the judge to come back. Pedantic means someone excessively concerned with minor details, rules, and displaying academic knowledge. The word of the day is goose, says Redman. We need a second word of the day. Computers don't blow up after 5 years. Well, I will just say he got a Dell. got Adele. And Dells ain't cheap because they're great. They're cheap because they, Not Adele. That would be expensive. Rumor has it, yes. Speaking of computers breaking and everything else, I have tomorrow morning. I have another trip down to Kinston to let somebody into the building to fix the Lexmark rebranded Xerox printer. They're going to change out the surprisingly motherboard and interface, and hopefully fix the printer that I installed.
I know we're going to hear something any minute. They're just talking. Okay. Just like last time. We had to wait. But it says private there.
Yeah, it says private, but it's not. I thought we were coming back to Judge Simpson's
pretty flowers that they brought in. Really? Yeah. Nice arrangement.
Not sure what we're... Jules is confused. Possibly new to the court system. Could be something else as well. It's a little strange. We might bail on this for just a minute while we wait for the judge to come back. Give us a second. Let's see who else. So we can go back to Judge Dad, see if he's come back from his break. Goggins is back. Judge McBurney's holding court. Not sure what his is about. Let's check.
There on that day, and he did take the headphones of the victim. The headphones were returned back to the victim in this case. However, the shoes was taken by another
judge. Just came back.
Another co-defendant.
I'm going to do, without going into great detail, there's the competency review hearing, which is set for August 6th at 9 a.m. I'm also going to set a status hearing in this matter for June 25th, 2026 at 9 a.m. for other reports to the court on this case. All right.
Thank you, Your Honor.
Thank you. At this point,
I'm going to you guys now, okay?
Bond with its conditions will continue. Righty? Okay, thank you.
Right, these are probable cause conferences with Judge Simpson. Disconnect Jules.
Is it done?
Yeah, it's done.
Court does call the case People versus Jabby and Lovelace.
And Assistant Public Defender, let me talk on behalf of Mr. Lovelace.
Who is present wearing
Mr. Lovelace,
what?
can you please state your full name for the record?
JB and Lovelace, Your Honor.
Your Honor, we're requesting an adjournment.
Did he just like pick up that piston shirt, or is he actually wearing it with pride? Huh?
I sleep in this, Judge. I never take it off.
Are you just trying to show off, or what are you doing?
I want to win.
Okay, all right.
Fixation, Your Honor. I forgot what I was saying.
I know, me too.
Yes, I was asking for an adjournment.
Yes, you.
The media that was provided to us is incompatible with our systems. So I did reach out to Mr. Cook, and we're working on getting compatible.
Okay. All right. Probable cause conference, I'll adjourn it out May 28th, 2020.
PCs and Macs.
Thank you, Your Honor.
Talking to each other.
Bond continue. Thank you. And go Pistons.
That's on the record. Alan's here. Awesome.
Court does call the case. People versus Milnacia Crosby.
Mr. Public Defender Job, you lead on behalf of Ms. Crosby.
Who is?
Would Ms. Crosby be logged in by any chance? I believe she's in the Wayne County Jail. And Your Honor, I do believe I know what's going on there. My understanding is Ms. Crosby is actually in a trial today for a charge in Wayne County. So I'd be requesting an adjournment.
That it.
Yeah, that's a good excuse.
County did not.
Judge, I can't come to court. I was in another one.
I'll adjourn.
48, Your Honor.
Yes. Thank you. 2020. A bond continues.
Thank you, Your Honor.
Mr. Allen, get a fresh braid, a new do.
Is that it?
Never.
Serious? Wow. If you hadn't made that guy mad, you'd have been out earlier. Anyway, works in recess.
Right. Judge steps away. We're going to jump back to McBurney, see what happened with the shoe stealer.
All very interesting things. I don't know if Ms. Cheney has something that she may want to add because she has been with him in court. The last time I know she was definitely present in support of him and very interested in how this case resolved.
Okay. Ms. Cheney, anything you want to add?
He's just been doing very well in the program. So I'm going to graduate from the program in July.
In like 2 months?
Yeah.
Okay. And Youth Opportunity is what the program is called?
Opportunity Union, yes. Under Judge Crawford.
Okay. Youth Opportunity. Did you say there was one more word or it's just 2 words?
Unit.
Youth Opportunity Unit. Okay. All right. And that's something he's been doing in connection with his entering auto case.
Yeah.
Got it. Okay. Thank you. Mr. Lee, you're a dad.
Yes.
At age 18. Boy or girl?
Girl.
Okay. And where does she stay?
Well, her mom.
Okay. How old is her mom?
16.
16. Is she a student somewhere?
She go to Phoenix.
Pardon me?
Phoenix.
Okay. All right.
It's tough. It's a tough start.
Anything you want to share?
Need support.
No?
No.
Okay. Well, Mr. Lee, I find there's a factual basis for your plea. You and Jacoby Johnson and Vincent Russell, and it sounds like a couple other guys, had a dumb plan. It's good no one got hurt. It's good Mr. Wilkerson didn't pull out a gun and shoot you in the head, and he would have been justified in doing that, and that would have been tragic for your family. And you wouldn't be a dad. Obviously, you need to not do something like this again. You're using up your first offender on this one. So if something like this happens again, you don't get to hide behind, I've never been in trouble before as an adult. And you're legally an adult now. So it's the serious times. I also find that your plea is knowing and voluntary, meaning you've understood the things we talked about. You agree with that?
Yes.
And voluntary, no one's forcing you to enter this plea?
No one.
No one. Good. Mr. Lee, I have in my hands a form called plea of guilty. You put your initials next to a whole bunch of things and talked with Ms. Cabrera about it. Did you sign this document on the second to last page?
Yes.
You understand it?
Yes.
And Ms. Cabrera, you signed it as well? Ms. Cabrera, can someone in my office sign the indictment on your behalf?
Okay.
Ms. Smith?
Yes, sir.
And Mr. Lee, can we sign your name to the indictment indicating your first offender plea?
Yes.
Okay. It sounds like, Ms. Smith, there's no restitution. I mean, there are these shoes that are missing, but you're not moving forward for restitution at this time. Okay.
He's got a Ferrari hoodie on.
So guys wear those kinds of shoes?
Balenciaga.
Yeah. All right. Interesting.
All right.
Mr. Lee, I'm going to sentence you as has been negotiated. I would have probably done a little less probation, but I understand the value of having a longer off-ramp to keep you on point longer. 7 years probation. Special condition number 1 is that you graduate from Skyview or get your GED, and that happens within the next 12 months. So either you graduate, sounds like you'll be doing that in December at the latest, is that right?
Yes.
Okay, or you get your GED, 12 months. No contact with Mr. Wilkerson. Is Jacoby Johnson someone you know?
Yeah.
Is he at school with you?
Nah.
Okay, no contact with him. Is he a neighbor?
Nah.
Okay, Vincent Russell, do you know him?
Yes.
You're laughing. Why are you laughing?
Because his name.
Okay. Well, funny or not, that's a name you got to stay away from. Is he at Skyview with you?
Nah.
Okay, stay away from him. You'll need to complete 60 hours of community service. You need to do that within the first 6 months of your probation. And you need to complete the youth opportunity unit. Sounds like you're almost there, but it also sounds like that has been helpful for you. If they tell me you flunked out or whatever happens, then that's going to be a violation of your probation. I will set a behavioral incentive date of May 8th, 2029. That's 3 years from now. If you have done all the things you needed to do and stayed out of trouble, 0 arrests, then we can end your probation early. But if it's been bumpy, you haven't been showing up for probation, you're not doing the things you're supposed to do, then 4 more years probation. That's fine with me. But you could earn an early exit from the sentence. And I will sentence you as a first offender. I believe you understand the benefits of it and the risks of it. Ms. Smith, anything else for the state?
Nothing further, thank you.
Ms. Cabrera, on behalf of Mr. Lee?
Nothing.
Mr. Lee, what county do you live in?
Are you in Fulton County?
Where
are you?
I'm on the west side.
Are you in Atlanta?
Yeah.
That's Fulton County.
Oh,
Unless
okay.
you're south, but.
Yeah, Fulton County.
Fulton County. All right. You're going to need to report to probation in a little bit. Ms. Simpson, who's seated
And
there in the
take a
jury
geography
box, she's going to
class.
come meet with you and Ms. Cabrera real quickly to just get contact info for you. She's going to give you a piece of paper. It's going to tell you when you need to show up for probation. That is a hot date. Do not miss it. If you miss it, they're just going to send me a warrant, and there goes your behavioral incentive date. Okay? Any questions?
Nah.
How'd you get here?
Bus.
Where are you supposed to be in school now?
Yes.
You going back to school today?
Nah.
Why not?
I only do morning session. I can only do morning session. I can't do afternoon session.
Why not?
Because I can't. I got suspended for fighting.
At school?
Yeah, and I can only do morning.
When did you get suspended for fighting at school?
I don't remember.
Well, give me a hint. Yesterday?
No, didn't happen.
A year ago?
Nah, probably like a couple months, 2 months ago.
Okay. And do the folks at Youth Opportunity Unit know that he was suspended?
Yes.
Okay. All right. Good luck, Mr. Lee. I really hope, don't take this the wrong way. I hope I never see you again. That would be a good thing for you, unless I run into you because you're successful at doing whatever you're doing outside of the courts.
Thank you, Claire.
Thank you, ma'am.
I'm
Good
not
luck
sure.
with everything else. We'll send an email out about,
Monday.
yeah, I'm getting conflicting info about Mr.
Yeah.
Melnick's availability.
I'm not sure if that's going to be successful.
Well, not the judge, someone else in the chambers. And then Mr. Abadi shared what he shared. I'm gonna go with what the judge says. So I need to shoot her an email. I've just been stuck out here.
I get the impression that the trial is ending. I just don't know that they know when.
Juries will do what juries do, right?
That's a good quote.
All right.
Oh, no. Our favorite. She bailed on me right as I went to her. Oh, my goodness. Why is she gone? Let's see. Just going to go down to Texas briefly. We can still visit Texas, maybe. Nope, this judge is gone. He's on break. Flag's still here.
You are banished from the state of Georgia.
Banished. Fulton County especially. Just not allowed there. Love to go visit Josh sometime and go fish off the dock where he catches his massively huge catfish. I just can't go to the state. So, all right, hold up. Does anybody know what time the hearing is for our boy? Where's our boy? You guys know the one whose name Caleb Flynn. Any other case, I will remember. Any other case, that one I will never, for some reason, I just cannot get. Caleb something, right? Hang on, what's this one? Closed session. Ah, that's no good. Can't do closed sessions. Hey.
Hi. Are you right?
I am.
Can I see your phone for a second?
You don't steal my phone?
Well, you can just tell me. Are those window people open on Saturday?
I don't know. All right, let's see if possibly Clinton Circuit Court in Kentucky. What says you? Should we jump there?
Did they text you?
No, they called.
Represented by, you have an attorney? We have a good court.
Is this Cinder Block Courthouse?
Continue to make sure I sign that. You have a right to remain silent. The grand jury of Clinton County has returned into that and charging you with terroristic threatening.
Oh, what?
And disorderly conduct.
Terroristic threatening?
Yes, sir.
Did you say I'm going to come back here and do XYZ? That's terroristic threatening.
You acknowledge receipt of the indictment, Wade Marie and Raymond interpleading not guilty of children all pre-trial motions.
Yes, sir.
Yes, sir. Okay, I'm signing a reciprocal discovery order here. Schedule a negotiation date for May the 29th and the next court date for June the 4th.
On my bond, Your Honor, is there anyone else that can be approved that can sign my surety?
What's the bond? Wait a second, ma'am. I'm checking it out.
It's a $50,000 surety bond.
Judge, Ms. Tucker contacted my office and she indicated that some folks had tried to sign a surety bond for her. And Judge, I'll be honest with you, a surety bond for about half my clients, if not more than half, is equivalent to a property bond or a cash bond. Just because
the clerk has to approve it.
Wait a minute, please.
I'm sorry, sir.
You know, they're low income, they're indigent, and most folks don't have the resources on my case.
Do you have someone that you would offer on the bond?
I tried to get my little brother to sign it. Calvin Starnes was going to sign it. He brought in his deed to show him that he had the property to cover.
What was the guy's name?
Calvin Starnes.
You know Calvin Starnes? That ain't fine. Yeah. Yeah, we'll accept Calvin Starnes to do it.
Okay.
Okay. I've accepted 2 or 3. Evidently, they've been signed.
I mean, like, I have property.
Okay, we'll do Calvin Starnes can sign it. Clerk approved it here. Okay.
All right. Thank you.
Back to you. Okay, Wayne County. Wayne County, down there. There you go. Sherry Barnes, Wayne County.
Hold on. I let Sherry Barnes. I still let Sherry Barnes. Let Sherry Barnes. Oh, yes, Sherry Barnes. Thank you.
These cameras are really good quality. Audio's not there.
Get Jonathan Ray, are you there? Yes. Jonathan Ray, while we're Commonwealth versus Jonathan Ray, 26 CR 0033. Mr. Ray, were you born in 1986?
Yes, sir.
Last 4 digits, social security number 4460.
What? You're going to go
33 for you have the right to remain silent. Your attorney's here. The grand jury of Cumberland Clinton County returning indictment charging you with failure to use a seatbelt, careless driving, following another vehicle too close, reckless driving, operating a motor vehicle under the influence for subsequent offense. Possession of open alcoholic beverage and being a persistent felony offender. Again, no charges.
Was this a grand jury for not wearing a seatbelt?
Identity your client receiving indictment, wait formal reading and arraignment, enter plea not guilty.
Yes, Your Honor.
Reserve all pretrial motions. Sign a reciprocal discovery order, sir. We'll schedule a negotiation date for you on the 29th of May. The next court appearance is June 4th. Both of those are conditioned to the law. Okay, thank you. Charlie York. Charlie York. Are you Charlie York? Sir. Good morning. We're on 26-0041 26 CR.
We're going to bail from this one. The audio's just terrible.
1970.
Plus, they're giving away social security numbers, and we don't want to do that. All right. Back in Goggins. Nothing doing. They're quiet. Let's see. I think Judge Boyd's live. See how Judge Boyd's doing down in Texas real quick.
Moving, because otherwise,
yeah.
You
know. The only sport I play is pick a piece of metal up and down and walk away. 30 seconds max. So that's it. And then I'll walk 1 mile at home. Thank you so much. You too.
Welcome.
She's in a good mood.
I'm working on it. All right.
It was supposed to be today at 11. Let's see if this happens.
All right. Anyone else ready? Richard Ramos.
We've seen Ramos before, I'm pretty sure.
It's awesome.
There you go. It is now. As a kid, it wasn't so great.
Oh.
Now it is.
Oh, well, I imagine with your
She gone. She gone. Trying to check on Flynn. Surfing Selena says, it's completely confirmed. I'm going to be in the courtroom for Karen Reid sentencing. That is awesome. You'll be one of the few who is able to get in that is not family. So let's see.
Fine. You too. All right. Thank you. All right. This is Ramos.
Yes, ma'am.
Yes, Your Honor. Okay.
Yes. Right.
All right. What's going on here?
Your Honor, we have an offer from the state. We are going to consider the offer.
All right.
We could just
So we would like-
a deadline.
All right. So if you all can get me an acknowledgement of discovery.
Sure.
Oh, there you go.
And then how old are you?
39.
All right. Norm, I need a plea deadline date in 3 weeks, please.
Did I say Karen Reid again?
May 28th.
All right. We'll be back on May 28th. Once you sign the reset form, you are excused.
Corey Richards.
Thank you.
Thank you, Your Honor.
You're welcome. Who's next?
Okay, Selena, we've passed a new law. You can't say KR anymore. You have to spell out the name every time. I know it's a pain in the butt, especially if you're on the phone.
Aaron Mendez Trevino.
You gotta spell it out.
Is he here?
No, Judge, he got arrested last night. He's in Bear County Jail.
You got arrested?
So I did confirm that. It looks like it's a THC case of some sort. But I talked to his father this morning, and he is in the Bear County Jail.
Okay. Let me see here. And he signed up for PTD.
He was in
Corey
PD. He
Richards.
originally got revoked out of the PTD program already.
Okay.
And now he's picked up the case last night.
Yeah, he's getting.
And is it a misdemeanor? Do you know?
No, it's THC, so it'll be a felony.
Okay.
There might be a second case, is what my paralegal told me, but I hadn't been able to look it up. A drug case. He picked up one or two drug cases.
Okay. All right, Norma, on Trevino, Mendez Trevino, recall both of his cases.
Selena, you're good. It's my bad.
For 45 days.
My mistake. I'm sorry, Judge. My mistake. I was busy working on the new product, so.
Is in custody at the Bexar County Jail, and that's why they are not here. So it'll be recalled for June 22nd.
Thank you, Judge.
All right, thank you. See, he's on that page. And all right, thank you. All right, Tiana Villarreal. Sonia Hickman. Lionel Young. All right, you need to be on the second row. Second row on this side. Xander Vargas. Garrett Dillon. That needs to be reset, I think. Contact their office, Norma, to see where their client is, but I know they were asking for a reset because the attorney is out of county. All right, thank you. Okay. All right, thank you.
All right. Love Judge Boyd's flowers today. Looks good. Looks beautiful. Oh, she's got the purse vase out too.
I think she's one. I'm sorry. Thank you.
All right. If nothing happens, we're going to Burnett, Judge. Okay, we're going. We're going. Jump. Joe Rosenthal. Are those records he has on the wall? It's like music collection. And he has a number of wires. I see a speaker. Is he a DJ in his spare time? It looks like over his shelf he's got some records.
I only received one.
Over his shoulder. It's like the music lawyer.
Fresh.
Somebody tell me what those... I can't read it. Somebody tell me what bands those are.
Okay, 2 is fine.
The way the cables are sort of protruding up like that, I think he's got an audio board.
I got the letter from Rosenthal.
Poor Karen Reed going to jail for something Corey Richens did. Oh my goodness. You guys just won't let me live it. Oh, well, it's my own fault. I won't get over it, but.
There we go. Okay. All right, that satisfies the court. So I will go on the record, but we'll go on the record in the matter 25 CF 72, State of Wisconsin versus Jacqueline Duncan. The state appears through District Attorney Kevin Schmidt in person. Ms. Duncan appears in person with her counsel, Joseph Rosenthal. We're set here today in this matter for plea and sentencing. However, the court has received a request from Mr. Rosenthal asking to adjourn it for medical reasons. The court has received the necessary medical documents to review and to make a determination that the court does find good cause to adjourn. So I will adjourn the matter. I believe we would need to look at September.
Okay.
Is that correct?
That would be my request, Your Honor.
As long as there's no objection from the state.
No objection.
This judge and this lawyer have history.
Make sure whose case this is, Mr. Schmitz. Okay.
I believe the judge removed this lawyer from a case back in December.
And was it August 22nd or 1st or something?
The 22nd, but I don't believe my doctor's going to have me go full term. She might have like a week or two early, so it's still in the air.
I just want to make sure that you have at least a couple weeks recovery.
Okay.
Yeah, this judge kicked this attorney off a case in December.
What about
for ignoring a court
September
order?
9th at 3 or September 10th at 2?
Either is fine with me. I think I'd prefer the 10th.
Let's do the 10th at 2. Ms. Duncan, just take care of yourself. And I am setting this for a plea and sentencing because that's what I'm told that it is.
Okay.
If this is not going to be a plea and sentencing, then you're going to have to let me know because we're going to have to reschedule the trial. But as far as you're concerned here today, Ms. Duncan, you're accepting the offer?
Yes.
Okay.
Yep.
All right. You can come get your notice and you're free to go.
Okay.
Thank you.
Thank you, Judge.
Thank you, Mr. Rosenthal.
Judge, does that mean we're done? I guess I'll take that as a yes. Judge is reviewing the same. Give her a minute. Boy, I bet she says okay first thing. I live in Wisconsin and don't hear any accent, and there was an accent. Kayla, thank you.
All right. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're just asking the court to follow the recommendation that the state is making and agree to the 1244.
All right. Mr. Smith, why do you keep doing this?
Well, I was a little tipsy. I wasn't really thinking I was being arrogant, I guess.
How old are you?
I'm 55 now. December 13th, I turned 55.
Okay, so here's the thing.
if you continue on the path that you're on, you're going to keep having not favorable contact with law enforcement, right?
Well, yeah. Well,
So you're going to have to change. And if you have an alcohol problem, which from reading the police report, it appears that you do, you should not be drinking alcohol at all.
that's true.
And when you're released from custody, do you have a place to stay?
I'm going to go to Haven for Hope.
All right. And at Haven for Hope, I know they have different programs. You need to try to get into a program that can help you with your sobriety, okay?
I was definitely planning on that.
All right. And then you can also look at lifetime recovery.
Okay, I haven't heard of it.
Oh, yes. So we'll make sure that you get that information, okay?
Okay. Yeah.
All right. And is this anticipated a judgment satisfied or no?
Yes, Your Honor.
All right. So the court is going to sentence you to 170 days in the Bexar County Jail under 1244. Give you credit for any time served. There's to be no unsupervised contact with minors. And the court will show this is a judgment satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, just give me a moment. Let me give you the information on lifetime recovery.
All right. Thank you.
You're welcome.
And I have watched Night Gallery before, by the way.
Yes. Wasn't it awesome?
Yeah, it's a pretty good show. Rod Serling even was the host for a while. He did Twilight Zone.
Mm-hmm.
Kind of interesting. Interesting.
I hope Judge Boyd's picture goes up on the wall when she's done serving. What does it take to get your picture on the wall? You don't have to like pass away, do you?
So there's their information. All right.
And Your Honor, just so that we're clear, you made a statement regarding minors. Can you please explain that to my client?
Oh, because based upon what I was reading in the police report and where
the HEB part.
She mutes herself. It goes off the record. Not sure what that was. All right. McBurney, you got anything for us yet? Says no. Simple no would suffice. We're waiting for word on when the court case is going to be up in Ohio for Caleb Flynn, remembered. Not seeing it. When Flynn, that's right. That would be, if Boyd gets to be on the wall, she should choose her picture to be a very stern one, just given like a major crusty, like just like glaring at whoever's sitting, you know. Well, you paint the picture so it's facing forward, but wherever you look at it, it looks like it's looking at you. And just be like, Or she should be like holding up a YouTube plaque or something like, I have this many subscribers. I think that's what it should be. So the next judge has to look at it every day. Should have her YouTube for sure. I was just typing that. We think alike, Red Pen. That would be fun. Of course, it's going to be more professional, and she'll be smiling, and it will be dignified and everything else. But let's see. Thurston County, do you have anything happening?
Again, that's going to really get in the way of everything you're accomplishing right now. And so that means I'm just going to close this case today. Hasn't been the best, but there haven't been new law violations, and you've got sobriety. And so those are the things we were really reaching for. So get up to Fife or call them or Zoom or something so that you can clear that up. And then you're not going to have any more obligations. I'm going to waive the fines and fees here. I don't think it's realistic to have that imposed any longer, especially the fee that goes to public defense, because finding you're indigent and unable to contribute. And that's it for this court. But what you're doing for the victim impact panel, I would keep doing that. Get that proof up to Fife, get a hold of Fife, see if you can clear that warrant.
Wait, so my question, do I gotta send you guys it too, or?
Nope, you're done with us.
So we're done today?
Yeah, we're done today. That's it. So
the scrolling is so
yeah, deal with Fife. All right. Well, good luck. Good job on 2 years of sobriety.
Thank you. I appreciate it.
Congratulations. That's awesome.
Well, it's a lot. You're right.
All right. You guys gotta go, or?
You can go.
You can go.
You guys
We're going to jump to Good Hair. Not Dr. Good Hair, but just the Good Hair himself. We met this guy the other day. State prosecutor with luscious locks. The guillotine courtroom, where all cases are decided at the sidebar. As you can see there, that is the actual bar, where everyone has a spot, a little notch in the table, a little indentation on which to lean, and to make their arguments recumbent style. This is Fabio. I don't think we learned his name yet. I didn't hear it. Got to know what that little box is in the corner. Could somebody, like, honest? Has anyone been to this court? It's what? Were we in Texas? Yes, we're in Texas. Has someone been to this court and can tell me what the? It's the caveman from Saturday Night Live. It's where they make their counter arguments. Counter should be capitalized or at least italicized. But state, we're in Texas here. It's just a post-COVID divider. But why is someone sitting behind it? And they're looking at things. Like the bailiff was just like pointing at, like they've got screens or something there. It's like a workstation of some sort. There's a monitor. That's what got my attention. That means video. It's Ross from Poldark. I think he's got more hair than Ross did. It's like a stockade frame. I was thinking guillotine. Stockades and guillotines are basically the same thing, only one. I mean, they hold you for different reasons, right? It's basically, a guillotine is sort of like a stockade. Just the duration's shorter and the result is more permanent. Maybe she's streaming you. Could be. I'm Super T, just an FYI, 160 days smoke-free. That deserves at least a little bit of a celebration. That is awesome, Super T. Congratulations. Why can't we hear this? It's just the judge has turned off the mic right now. He'll turn it back on when he's done. Conferring. I was clapping for his 2 years of sobriety. I love hearing that. I've never been an addict, but I'm so admire those who have gone through it and came out better and stronger. Katie, thanks for the support. That is awesome. That is really cool. What if there's a footrest on the floor so you can take some take a load off? Yeah. Take some lead off. At least rest your feet from the heavy chains and shackles. You can belly up to the bar on this one. Quite literally. Just belly up to the bar. Hang on, is the judge wearing latex gloves? Watch his hands. Watch his hands. Wait for it. Wait for it. He thought he was leaving, but he's not. Point again, Judge. Point again. I think he's wearing latex gloves. He always wears gloves. Why? Is it like a sanitary or obsessive compulsive type situation? I mean, I understand if it is. I'm not knocking him by any means. I'm just curious as to the reasoning. Can we turn the audio on, Judge? There we go. Click. Click us, Judge.
Okay, court is in session. Clause number 24 CCCR 2518. Case is filed in the state of Texas versus Richard Gage IV. Mr. Gage, is that your full name?
Yes, sir.
How are you doing, Mr. Gage?
I'm doing good, sir.
That's good, Mr. Gage. Would you please raise your right hand?
Those are
Mr. Gage, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Gage, you may put your hand down. Mr. Gage, you're represented in your case by your attorney Todd LeBlanc. And Mr. LeBlanc, do you waive a record in Mr. Gage's case?
We do, Your Honor.
Mr. Gage, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Richard Gage IV, on or about August the 8th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury. Mr. Gage, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Gage, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Gage, I also have before me a document that is titled Misdemeanor Plea Admonishments. You recognize this document? On page 2 of this same document, there's a set of initials RG on the line next to a box that's checked.
Yes, sir.
Nola contendere, did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And at the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Mr. Gage, before you sign and initial all the documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over? Is everything in these documents true and correct to the best of your knowledge? Mr. Gage, are you a citizen of the United States?
Yes, sir.
State Upper States one, Your Honor. No objection.
No objection. States Exhibit number 1 will be admitted. Mr. LeBlanc, you have advised and counseled Mr. Gage. Is there any evidence that he is currently mentally incompetent to stand trial?
None of them were.
And Mr. Gage, your attorney, Mr. LeBlanc, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation.
Yes, sir.
Mr. Gage, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers was freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
It'll be 8 days confinement in the county jail with credit for 8 days time served, court cost, tax, and retirement.
Okay, Mr. Gage, the state is offering that you serve 8 days in Jefferson County Jail, but you would not have to serve any more time in Jefferson County Jail because you already served 8 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Gage, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Mr. Gage, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Gage, if you do not have anything else holding you in jail, you should be getting out of jail today. Now, Mr. Gage, you're going to stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to follow the bailiff and you have a blessed day.
Thank you.
All right. So, quick quiz. How many times did he say Mr. Gage? Think back. How many times did he say Mr. Gage during that little appearance? There's a closer look at the whatever device that is back there. 12? I think it was 12 in the opening sentence. Skin condition, wears gloves a lot. Could be. Going to test wearing gloves and also let you get a better grip on papers and prevents greeners. Thank you very much. The 17th. All right. The 17th. Oh, someone's going through the metal detector. Oh, no, that's the door. Not the 17th. 9/17. Oh, my goodness. September is Caleb Flynn's trial. Well, we'll put that on the calendar. Guess I'm stuck with this avatar for a while. Oh. I think it might be just like a plexiglass. Because they also have like hand sanitizer there. And probably some gloves. And I think on the bar, just to the side next to the little box, I think that's a fan. Because there's also a fan down on the ground, maybe right here. I think there's a fan there and there's a fan up there. There's fans all over the place and a monitor. Think it's germophobia? Could be. On the bright side, that gives you 4 more months to learn his name. That's probably why I wasn't mentally. I knew this was going to happen. What are you carrying? Food? You bringing food in here? I'm going to back up just for a minute. Please tell me that was food and not something gross. What's this? What's this she's carrying there? Just checks to see who's here. We've got an inmate here with no bailiff. What's happening? What's she holding? It's food. It's her lunch. She's carrying it low so nobody will see. She thinks she can get away with it, but we've caught her in 3D. Well, not 3D, but 2D. I saw food in the courtroom. Linda Lou. Let's see. Wears latex or nitrile gloves on the bench due to germophobia and desire to maintain cleanliness. He's mentioned various proceedings and interviews. He prefers to avoid contact with documents. You never know where a document's been, or who's touched it, or where their hands have been before they touched it. He's in the same court as Judge West. That would explain the ceiling. We can't court hop till then, Posty, you're right. We'll have some cases between now and then. What happened to speedy trial for Caleb Flynn? I think Caleb Flynn asked for the extension, and when you do that, you're basically waiving speedy. That's why he goes digital. Look at that hair. And the tie? The tie is spot on today. I mean, yesterday he like threw it on as an afterthought. Today it's like the centerpiece of his whole attire. Tell me, is that naturally curly? Or does he do a perm?
Okay, this is cause number 25 CCCR 3020, case of Styles of State of Texas versus Tiana Elise James. Ms. James, is that your full name? How are you doing, Ms. James? That's good, Ms. James.
Got three
you
names.
represented in your case by
Ms.
your
James,
attorney Todd LeBlanc. Ms. LeBlanc, do you have a record in Mr. James' case?
4 times.
Ms. James, the state is represented in this case by attorney Samuel Masradian and Mr. Masradian. I have before me a motion to dismiss. Is that correct?
That's correct, Your Honor.
And Ms. James, I'm
6.
signing this motion to dismiss this case. You will be able to get a copy of this motion in order to dismiss from our court coordinator. Once you get a copy of this order dismissing this case, you're free to go. And you have a blessed day.
Only 6 times.
Okay? Please stand in front of the court coordinator.
Okay. Judge Boyd is live. Judge McBurney looks like he's about to have something happen. Thurston County just came on. Let's check them real quick.
Matter ready to go? That's right.
Yeah, Miss Wheeler's back. I don't know if the attorney, oh, there we go. Yeah, he's here.
All right. Morning, sir.
Good morning, Your Honor. Eric Kupka on behalf of Amy Wheeler.
All right. And good morning, Miss Wheeler.
Good morning.
All right. Looks like in full name, Amy Lynn Wheeler.
Correct.
All right. Date of birth, March 18th, 1970.
Yes, that's correct.
All right, ma'am. We are here for an arraignment on one charge of theft in the 3rd degree. Sounds like you've had a chance to speak with Mr. Is it Kupta? I'm sorry if I'm not pronouncing it.
It is, Your Honor. Thank you.
All right. So next I'm going to turn to Mr. Kupta to make a record on the arraignment. Go ahead, sir.
Thank you, Your Honor. At this time, we will waive formal reading of the criminal citation, enter a plea of not guilty, and we'll also waive advisement of rights.
All right. So, Ms. Wheeler and Mr. Kupta, is there any position on probable cause?
Actually, I haven't received a probable cause statement, but I did receive discovery I think it was yesterday, and I'll stipulate to probable cause.
Okay. All right. So, Ms. Wheeler, the court will enter that plea of not guilty to the charge. Looks like you've retained counsel. Next thing we're going to do is I'm going to turn to the attorneys for recommendations on release conditions while the case is pending, starting with Mr. Sabota here in the courtroom for the City of Lacey.
I just ask that you have law-abiding behavior, make all court appointments, maintain contact with attorney in the court, and maintain address and the necessary address info for contact with her attorney in court, and make all court appointments.
Any request for a do not return?
No, there's a family law. There's a family law order. It's not in there. And we haven't really had contact with Mr. Wheeler at this point.
Okay.
So I'm inclined to just keep the status quo between the two cases, meaning the family law
case in this case and just leave good behavior condition.
Okay. And Mr. Kupta?
I have no objections to the release conditions. Ms. Wheeler has nothing on her record in the last 51 years. I don't anticipate anything.
All right.
And she's got good ties to the community as well.
Understood. So Miss Wheeler, you'll looks like you posted a $1,000 appearance bond to be here today. Court's going to exonerate that bond, so that will come back to whoever posted it. You'll be out on your own recognizance, meaning you don't need to post any further bail or anything like that. Conditions of your continued release while the case is pending is law-abiding behavior. And we're going to next set a court date for you. And that's going to be, it's going to be the same. Okay. Still at 9:05. All right, so that's going to be June 8th at 9:05 a.m. for your pretrial hearing.
Your Honor, did you say Monday, June 8th?
Yes.
Yes.
At what time?
9:05. We scheduled that for the private attorneys, so they're all grouped at the same time.
All right. Is there anything later in the morning that I could bother the court for? I may have a scheduling difficulty with Grace Harbor Superior Court.
Okay. Or we could move it a week. Yeah. All right. How about the June 15th instead?
I may end up with the same problem, but I'll take it for now, Judge.
Okay. All right. Thank you. And Ms. Wheeler, so that will be June 15th, again, 9:05. All right.
Thank you very much, Your Honor. And, Your Honor, I may be a little late. If I am, I do apologize in advance to the court for that hearing, but I will be present.
All right. Thank you. Appreciate that. All right, Ms. Wheeler, filling out a judgment and sentence form, similar to the previous individual there. This goes over the charge, the release condition, and your next court date. You can get a copy of this from your attorney or off the Thurston County District Court website.
Thank you.
Thank you, ma'am.
Thank you very much, Your Honor. Thank you, Mr. Sabota and Ms. Wheeler. We'll be in touch.
Thank you. All right. Now, good morning, Ms. Capone.
Good morning, Your Honor. Could we please call Miss Waldo's matter on the 9 o'clock calendar?
All right.
She is present in the courtroom.
Ms. Waldo, good morning.
We'll go to West sometimes.
All right. And ma'am, is full name Lisa Jessie Raylette Waldo?
It's Lessa Jessie Raylette Waldo.
Lessa.
Yes.
Lessa. All right. And date of birth, February 5th, 2001?
That's correct.
All right.
Oops, sorry, I missed that
Ma'am,
one.
we're here for an arraignment on one charge of theft. Have you had a chance to speak with Ms. Capone this morning?
Yes.
Okay. Go ahead, Ms. Capone.
Thank you, Your Honor. I had the opportunity to speak with Ms. Waldo. I advised her of her rights, and I do believe she understands them. We're not contesting probable cause for today's purposes only. We'll ask the court to enter a plea of not guilty, and based on my conversation with Ms. Waldo, she does qualify for court-appointed counsel, so we'd ask the court to make that appointment at this time.
Okay, thank you. So, Ms. Waldo, court will enter a plea of not guilty to the charge of theft and appoint Pacific Point Defense to represent you. So you'll have a public defender helping you out moving forward on the case. Next, I'm going to turn it back to the attorneys for recommendations on pretrial conditions while the case is pending, starting with Mr. Sabota, the prosecutor.
Just as a clarification, is that a stipulation of probable cause or just not?
I think
is not objecting to probable cause. It's not a stipulation to probable.
For the purposes of this pretrial hearing only.
We'll stipulate for purpose of clarification.
All right.
No law violations, no contact with Safeway, clear Clallam County bench warrant.
Safeway, the grocery
make all
store.
Court appointments, maintain contact with the court, and her attorney make all court appointments.
Okay. And Ms. Capone?
With regard to the warrant, we would just ask that she make efforts to clear that warrant. As Your Honor knows, there sometimes are hurdles with that. Looks like according to the docket notes, she didn't get notice, and we discussed it today. She didn't know about the warrant, but I did write information down for that warrant, and she'll have it.
Okay. All right. Ms. Waldo, you'll remain, let's see, out of custody on your own recognizance. Had you posted a bond in this, ma'am?
It doesn't look like
No?
it.
Okay. No, oh, the page didn't refresh from the previous individual. All right, so you'll remain out of custody on your own recognizance. Conditions of your continued release include law-abiding behavior, have no contact with the Safeway in Lacey.
I think it's a grocery store.
Yeah, with respect to that Clallam District Court warrant, court will just make a condition that you contact the court regarding the warrant. I understand sometimes whether that gets recalled or scheduled before your next hearing here is not necessarily in your hands, but some effort to at least reach out to them will be a requirement. Other than that, we'll make your court dates and we'll set it for a pretrial hearing on June 16th. June 16th at 9. Do you have any questions, Ms. Waldo?
No, I do not. I would like to say, Your Honor, that I am in treatment, working on my problems and working with my counselor.
That's great.
That helps.
All right. Well, make sure to talk to your attorney about that too, and sometimes that does help in resolving cases. But well done. We're going to print you out what's called a judgment and sentence. Again, for all of the folks here, it's kind of titled that, but we also use it for pretrial orders. Again, this has your conditions of release, your next court date, and the charge on there. And we'll print you out a copy. And as soon as Ms. Capone grabs that for you, you're free to go.
Everything's getting pushed. Let's go check out Judge Boyd, see if she's got anything coming up. Not a lot of judges active right now. So we're having a little lull between big cases. Safeway is a grocery store. I think I've shopped at a Safeway before.
What do you mean, right?
People keep stealing my jokes. Don't make me become a member, Mary. Who's stealing your jokes? I'm sorry. If it was me, I apologize.
Follow her.
There goes our sentencing roll. Yeah.
You take a seat.
We were hoping for another verdict music today. Might not happen. Wow, that lawyer's tall. He's way back there, and dude's like, he towers over everybody. I think he's wearing size 17 boots, too. Not sure how he gets in the doorway. Probably ducks. It's like one of those science center optical illusion. No. This is watch when somebody walks by him. I'm talking about the guy in the center.
Oh,
lawyer in the center.
Porter, did he leave?
Mustache, white hair, gray pants, blue blazer jacket, holding the white paper.
All right, who do you have?
Page 1, second down, Sonia Hager.
Sonia Hager? Or Haga?
Judge, I'm present on that, and I'm asking.
Have your client come up.
She won't speak to me.
Oh, okay.
Okay, that makes it different.
I have a motion to withdraw that's been on file for a few months.
Motion to withdraw for a few months.
Okay, and you want to withdraw because she won't speak to you?
Well, there's been a lack of communication, so I thought it would be prudent to just withdraw.
Miss Haga or Haga? All right, this is your attorney. You need to speak to her. Otherwise, you're going to end up going to jury trial having not spoken to your attorney. So, Norma, if you can set this for a jury trial, and if you think there needs to be an evaluation file, then you can file for an evaluation.
I'm just asking the court to allow me to withdraw from this case, Your Honor.
Not just for her not talking to you. If there's something else, then.
I think she made it pretty clear in the paperwork that she filed months ago that she has asked for my services to be terminated.
Mm-hmm. Then You'll remain on the case until she hires somebody. Norma, set this for jury trial in 3 weeks. All right, you'll be back for jury trial on May 28th, and they'll bring you over dressed. All right, thank you.
Poor lady. It's been months since her client won't let her get off the case.
Your Honor, will you call Mr.
You had a chance to meet with Ms. Capone today?
Yes.
All right, go ahead, Ms. Capone.
Your Honor, I had the opportunity to speak with Mr. Wells, advise him of his rights, and I believe he understands them. We'll stipulate to probable cause for today's purposes only. We'll ask the court to enter a plea of not guilty, and based on my conversation with Mr. Wells, he does qualify for court-appointed counsel, so we'd ask the court to make that appointment.
All right, thank you. All right, Mr. Wells, so the court will enter a plea of not guilty to the charge of driving with a suspended license, 3rd degree, and appoint counsel to represent you. I'm going to appoint Chris Langley to represent you. So she's not with Pacific Point Defense, but another attorney who takes cases from court appointment. So she'll still be free of charge to you. Next, I'm going to turn it over to the attorneys for recommendations on release conditions, starting with the prosecutor, Mr. Spiller.
As continuing conditions of PR release, no law violations, not drive without license, insurance, and interlock if required. Make all court appointments, maintain contact with Ms. Langley and the court, make all court appointments.
Okay. And Ms. Capone?
No objection to those standard conditions.
All right. All right, Mr. Wells. So those will be your conditions of release. So law-abiding behavior, to not drive without a valid license or insurance. With respect to that ignition interlock device requirement, that is per Department of Licensing. So as long as you're following DOL requirements, those are the conditions of the courts. There's nothing separate from the court, if that makes sense. All right. Last thing we're going to do is set a pretrial hearing for you. Actually, it's going to be the same. 15th at 9. Okay. That's going to be June 15th at 9 o'clock. Do you have any questions, sir?
No, I don't.
All right. And this is all outlined here in the court order I'm signing. We'll get you a copy and then you'll be on your way.
Okay, thank you.
He's on page 2.
The evaluator was having issues accessing Discovery, so we got it in act time. And as of last Friday, she was saying she was ready to write her report, so it should be coming soon.
Okay. All right. Then Norma, on Angelo Montgomery, let's recall that.
Yes,
Let me see.
we can cover reports for your
Lauren, did she tell you how long it would take her to do her evaluation?
I believe she did do the evaluation, and it looks like an Odyssey. It's at 519 for disposition.
All right, Norma, set this after May 19th. All right.
Thank you, Jen.
You're welcome.
We could use a soft set about now. It's been a bit. All right, let's see. Let's see if we can find that one just for a second. Thank you, Josh.
For 8 years. With the previous conviction. Good job, Lauren.
You're promoted. You're the new first chair.
Oh, no. Yeah. I was gonna say, I'll write you a letter of recommendation.
All right, we're going to jump to this one that Josh found for us. Thank you, Josh. Appreciate that. Let's see what we got here.
Hey, Your Honor.
Hey, Your Honor.
Yeah, sir.
You were calling for Jenny Vance?
Yeah, that's what's on the screen name.
She's a defendant in my case, or I'm the defendant or plaintiff. I have this case against her, but we have the same phone plan, and like all of my stuff is under her Gmail, so it probably is showing up as her name.
Okay, so what's your name then?
It's Brian Leslie.
Leslie?
Yeah, it's Brian Leslie and Jenny Van.
Okay, so in both of them on the file. Brian Leslie and Jenny Vance.
Yeah, I haven't been able to get a hold of her at all, and I'm not supposed to be in contact with her, so
Gotcha. And you're on your way into the courtroom. Is that what's going on?
Yeah. I was supposed to be there in person, but
all right. No, I appreciate you making contact. So just get in here, and then we'll address things for you. Okay.
All right. It might take me a little bit of time.
Well, yeah, right now. But that's okay. Just get in here because you were set for a jury trial today.
All right. I'm in big trouble. I'm probably going to go to jail, huh?
No, I'm not telling you that. Let's just get in here and try and sort through things, okay?
All right, thank you. Yeah, we've always had the same accounts and stuff. I've always just let her set stuff up.
That's all right. I'm not going to hold that against you. I just changed the screen name on this one, but just make your way in and come into the courtroom and let me know you're here, okay?
All right. All right. Thank you. I'll be there. It might be after. Man, it might be this afternoon, and I'm so sorry.
Can't be that. I thought you were heading in right now.
I am.
Sir, why weren't you here earlier then?
Because I don't have a driver's license. I lost it for. I got a third offense DUI, and I was trying to contact you guys while I was in there. I sent over a couple of writs to get this taken care of. But I did 225 days, and then, well, now I just got a job.
Now it is not looking good. So you either got to come here pretty quick, or I got to issue a bench warrant for you. Okay? And I'll grab the file. We'll take a look at it. Okay.
Yeah, I'll be there.
Okay. Can we get his file? I'll take a look at it and see what. He was right the first time.
Walking in the park.
It's in a little bit more trouble. Are you and Mr. Rush getting along this morning? Yeah.
So we have to watch for when he shows up. Does he show up today,
Thanks.
Josh? It's funny. We watched after him and before him, but I didn't find him. I skipped him. Thanks for the new. No, he didn't show. Oh. Bench warrant.
This whole time you weren't even able to hear me? Okay.
I'm sorry?
I'm sorry. I didn't realize it was muted.
Yeah, I had you muted. So I'm doing other matters right at the moment, Mr. Leslie. Trying to figure out what we're going to do.
All right, I apologize. I am on my way in.
Okay. All right.
I'll be there.
Okay.
Thank you. I appreciate it.
Okay.
Bench warrant. Shall issue. Andrea Burkhart posts on Twitter just in the last hour that tomorrow is the ruling on Tyler Robinson's motions to continue the preliminary hearing and ban the cameras. That's a particular one we're very interested in. And it looks like everyone is anticipating the preliminary hearing will go forward as currently scheduled on May 18th. They're fighting hard to ban the cameras.
Gosh, I guess, boy, poor Robin's running back. Boy, we might do Rummer if we can.
The state has a lot of preliminary evidence.
I got the file. I guess any Vance and whoever our prosecutor is. Not sure what we got for it. It's Gildner. Strip matter.
Could be an interesting one.
Oh, the other, yeah. Okay. All right. Ready to proceed with Joshua Remmert. And you're here for.
Oh, yeah.
Okay. Okay, make sure I got who I got for what. Thank you. Mr. Remmert?
Yes, this is the one we saw before. We'll skip that one. We saw it before.
And Norma, Ryan Arnett, is he still not available?
Yes, we get to see more. We get to see more of Attorney Nestor. I think this is her last big push to ban cameras. We're going to be there for the Corey Richens sentencing. We'll carry that live for you. We've got updates from
Lionel Young,
the court PIO for us.
If you come
about that.
forward.
We'll have the feed live. That's going to be next week.
Hello. They tell me your attorney is in trial. Have you had any contact with your attorney?
While in jail.
I'm sorry?
Just while in jail, that's Sunday night.
All right, just have a seat. We're going to have somebody come talk to you, okay? All right, thank you.
Only while in jail? My attorney hasn't talked to me other than that. That's not acceptable. Do we have a shortage of attorneys in the San Antonio area? Looking to see if anybody else has come online.
Make sure it's one of those is
Judge Simpson's back. Let's check with him. Good morning, Judge. Afternoon, I guess now. It's 1 o'clock here.
Go way back, apparently.
Welcome. Yeah. Tell the judge your name.
Curtis Jackson. Thank you.
And Mr. Jackson just emailed me some mitigation information earlier this morning that I'd like to review, so I'd be requesting an adjournment for that purpose, please.
Probable cause conference, I'll adjourn it to May 28th. 2026, 9 a.m.
Thank you, Your Honor.
In case bonds will continue. Thank you, Mr. Jackson.
2020.
Court calls case People versus Andrew Leamy.
Good afternoon, Your Honor. Brady Cooks, People.
Good afternoon, Judge Colin Daniels on behalf of Mr. Andrew Leamy, who stands to my right.
Your name?
Andrew Leamy.
Who's
Yes, Andrew Leamy.
Thank you.
Judge, I haven't had a chance to speak to the prosecutor in this matter. We are requesting another adjournment. We are currently ongoing negotiations. I think we're going to be able to resolve this case in front of Your Honor.
Okay.
Can I approach with the form?
Hand to him.
Thank you, Judge.
Adjourn this matter May 28, 2026, 9 a.m.
Thank you, Judge.
Thank you.
Have a good day, Your Honor.
You do, sir. On the 20th. Gotcha. Court calls case People versus Miko Stewart.
Good afternoon, Your Honor. Brady Cooks, People.
Good afternoon, Your Honor. Yvonne Parabon Keller, PD 4328, appearing on behalf of Mr. Stewart, who was present via Zoom.
Mr. Stewart?
Yes, Your Honor.
Okay, state your name.
Mikos Deshaun Stewart.
All right. You're requesting an adjournment also.
I am, Your Honor.
They're all co-defendants. I'll adjourn this matter to May 28, 2026, 9 a.m.
Thank you, Judge.
All right, thank you. Thank you, Mr. Stewart.
Thank you, Your Honor.
Court calls case People versus Jimmy Lee Perry. He couldn't hear me call the case only because he's sitting in between Hall and
Sorry.
no, it's not your fault. I saw that they were talking like over you. I wouldn't have heard him either. I would have shut my ears.
I was too, I don't listen.
Yeah, you didn't even, I know. All right. Sir, your name?
Jimmy Perry.
Thank you. What are we doing?
Study for exam, Your Honor.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 19th.
We'll try for that date, Your Honor.
All right. Learn their examination in person, May 19th, 2020. You okay with that date?
Yes.
Okay. May 19th, 2026, 9 a.m. That's before
Judge Garwood.
Judge Garwood.
Thank you, Your Honor.
Thank you. Court calls case People versus Ashley Albert. Oh, there she is.
Sorry, Judge, I didn't hear the prosecutor's appearance, but Christina Costantino appearing on behalf of Ashley Albert.
Ms. Faltez.
Miss Albert, can you please unmute and state your name for the court?
Do we have her?
I see her on.
Oh, I've got two screens, that's why. Albert, can you state your name, please?
You're muted.
Don't know if they can hear us.
Judge, I saw her on and now I don't see her on.
See, you don't see her?
You
might have a second screen.
She's in the middle.
Salber?
You're muted.
I don't think she's connected to audio. Miss Albert, if you can hear me, wave your hand.
Yes, sure.
Huh?
She's connected.
I didn't, but she didn't wave her hand either, so I don't know if she can hear. Well, I got somebody else coming in now.
Oh, it's two of her.
What's her?
She may have two sign. She's got two sign.
She's got two sign-ins.
Yeah.
Or
Okay.
a double. A body double.
Sorry, Judge.
No, it's okay.
I couldn't hear off of my phone. I don't know what happened, but I couldn't hear anything.
Okay.
There we go.
We got you. What's your name?
Ashley Albert.
All right. Fantastic. We got through. We made it work. All right. Or you.
Thank you, Judge. This is a date and time set for PCC. We would be at this time asking to have this matter set for a preliminary exam. Discovery is complete to my knowledge.
All right. People had their witnesses available the 19th?
Try, Your Honor.
All right. Preliminary examination, May 19th, 2026, 9 a.m. before me.
It's just that one case.
Wonderful.
Thank you.
Thank you,
have to
Judge.
watch something else.
Not usually the response I get, but thank you. All right. We'll continue.
Thank you.
Court calls the case, People versus Michael Smith.
And Christina Costantino appearing on behalf of Michael Smith. Mr. Smith, can you please unmute and state your name for the court?
Unmute. Hang on.
What's it with your clients
I
and
don't
Zoom
know,
today?
Judge. I'm sorry.
My bad. I'm at work, guys. My name is Michael Smith.
All right. Thank you. All right. What are we doing?
Your Honor, date and time set for PCC. We would be asking for an adjournment of the PCC. I did send over some mitigation materials to the prosecutor, and I do think this case could use some additional further negotiations for potential resolution.
All right. I'll adjourn it to May 28th, 2026, 9 a.m. That works.
It does. Thank you very much, Judge.
28th.
Thank you, Your Honor.
Bond continued.
Thank you very much. Have a good rest of your day.
You do the same.
Thanks.
Court calls the case, People versus Nazir Malzoum. Malzoum.
For the people.
Good afternoon, Your Honor. Dan Guerin on behalf of Mr. Mazloum. Mr. Mazloum, can you identify yourself?
Who's that? Hang on a second. Oh, she's trying. He doesn't know how to turn it on. Copper. No. All right. Go ahead, Mr. Guerin.
Your Honor, we're here for PCC. My client remains out of state in Utah in a rehabilitative center. I'm asking for an adjournment as long as Your Honor's comfortable with.
All right. Do we know how much more time they have there, or?
His father believes it's a 90-day program, and he's probably 2 to 3 weeks into it. So maybe we just need a date in the interim.
Okay. Understood. Being in treatment, I'll adjourn it to June 18th without objection.
Thank you, Your Honor.
2026, 9 a.m. Bond continued.
Thank you. Bye-bye.
Thank you. Court calls case, People versus Michael McClure.
People.
And good afternoon, Your Honor. Joseph Alpier on behalf of McClure, who stands to my right. Mr. McClure, if you could state your name for the record. Thanks, McClure.
All right. And Mr. He's going to waive.
That's correct statement, Your Honor. I've discussed my client, not only the right to a preliminary examination, but the timeline in which the court would normally hold it. You would waive both, Your Honor, and choose to proceed, sir.
All right. Sir, is that correct?
Yes, sir.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir, Your Honor.
All right. People also waive their right. Preliminary examination having been waived, defendants mount over to circuit court on counts 1 through 3 with 4 following.
I'm sorry. I was looking at my calendar, Judge. We'd waive formal reading, stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
July 1st at 1:30 with Judge Conlon.
July 1st, 2026, 1:30 before Judge Conlon. Bond will continue.
Thank you so much, Your Honor.
Yes, I need information.
Yes. Apparently we'll get it. Court does call the case of the People versus Angelo Massa.
For the people.
Good afternoon, Your Honor. Brendan Volsky, attorney on behalf of Angelo Massa, who's approaching the podium to my right. Sir, what is your name?
Angelo Massa.
Yeah, we were last year looking for some blood results related to the operating while intoxicated event. We've gotten the lab results do indicate there will be further testing done. So we're going to wait for those. I'm going to reach back out to Northfield to see if they've gotten anything else. But ultimately, we are looking for an adjournment to get all of the discovery.
I have no objection to that.
Probable cause conference, and I'll adjourn it out. Why don't I go June 4th? Let's see where we are. June 4th, 2026, 9 a.m. Bound to continue.
Thank you, Your Honor.
Thank you.
June 4th, too. No. Oh, okay.
Court calls the case People versus Amari Edens.
Ashley Bellis with Pickles.
Michael Vincent on behalf of Mary Ayden. Get your name for the judge. Mary Ayden.
Thank you. Do you escape from your office? Where are your people?
They're watching me, though.
Where?
They're watching me.
This is like 2 days in a row. They've let you travel alone.
All alone. Of course, I have Mr. Hall here to help.
Yeah. And he left?
Yes.
Hey.
Yes.
Yeah, I got to send out a memo on the rules regarding Vincent.
Court rule 97.2.
All right. What are we doing?
Do you need adjournment or what do you want to?
For exam, we're looking for a date a little further.
Okay. Prelim exam. Oh, 4 weeks from now.
So.
Now you're going to get me in trouble, you know.
No, I'm not
in
trouble. I'm trying to keep myself out of trouble. What's going to happen? We're going to set a date. I'm going to ask you, is that a good date for you? You're not going to know. And then I know how this is going to work. So hold on. We'll get through it. Don't you worry. You're good. Okay. Discovery is all complete?
I think so.
All right.
No, we have videos. I'm quite sure we'll get them within 4 weeks.
Yes, come on.
It's
Takes a sidebar. Tony, if you got something out there, let me know. Everything's getting pushed out recently. Sentencing's.
All right, record to reflect we had a bench conference in this case. I will adjourn this matter.
I don't have dates, but I have it on good authority that they're watching.
I know.
We already put that on the record.
Watching him, but I don't know. I don't think they have a tracker on him. They just knew he showed up because.
I don't have dates, so I'll communicate with their staff.
All right, here's what I'm going to do. To adjourn probable cause, I'm going to go June 4th, 2026, 9 a.m. Go ahead and write that down, Mr. Vincent.
I got it.
Staff changes it. We'll just do that. We will let you know.
Thank you.
All right. Thank you. Thank you, sir. Bond will continue. Court calls the case versus Patrick Lay.
Your Honor, Michael Vincent on behalf of Patrick Lay.
Your name, sir?
Patrick Lay.
And
Your Honor, I'm going to be with respect. This one in all candor, I have not had the opportunity to review the mitigation material sent over, and also I'd like some time to do that simply first.
Probable cause conference. I'll go to the same date, June 4th, 2026, 9 a.m. Where's your invite indicates bond will continue. All right. Thank you, Mr. Lynn.
Thank you.
Court calls case People versus Cora Thomason.
People.
Is that it for you, Mr. Vincent? Good. Okay.
Good afternoon, Your Honor. Troll via Star on behalf of Ms. Cora Thomason. Ms. Thomason, state your name.
Cora Thomason.
Your Honor, we're asking for an adjournment. I believe the prosecutor will lay some things out for the reason for the adjournment.
That's correct, Your Honor. I had the occasion to speak with Mr. Starr earlier today. He sent me over, I think it's an alcohol assessment for his client. And we're trying to get to a more favorable resolution to her. And I think he also needs to do some additional investigation about the possible license implications for her specifically, if there's any convictions in this case.
She just received her restricted license hardship from the circuit court. She just received it like a week ago.
I can't give a reliable answer about what will happen if she pleads to the owner's UI. So Mr. Starr wants to do some more withdrawal next.
My belief is
But she got the hardship, but they weren't aware of this case. Is that what you're trying to indicate?
I'm pretty sure they were aware of this case.
Oh, okay. But you're just wondering if there's been a conviction, what happens?
Yeah, what happens to hardship?
Gotcha. I gotcha. So she just got that last week?
Yes, Your Honor.
Okay. Probable cause conference. I'll adjourn out June 4th, 2026, 9 a.m. See where we are on that part. All right?
Well, thank you.
Thank you, Mayor. Bond continues. Court calls case People versus Lewis McSwain.
I'll listen to paper.
Trovia Starr, standing in for the attorney of record, Mr. William Amadeo, on behalf of Mr. McSwain. Mr. McSwain, state your name.
Lewis McSwain. Okay, hands over here.
Your Honor, two things here. First, Mr. Amadeo has informed me that he has not received discovery yet, so he's asking for an adjournment. And then secondly, it's my understanding that there's a community corrections violation for positive for opioids.
And cocaine.
And cocaine. Okay.
So that you know, there's on April 10th, he was positive for cocaine and opiates.
That's when I first got out.
On the 17th, a week later, there's no drugs found, but he has diluted his creatinine. So he watered the test and it comes back with diluted creatinine levels. But then by the 23rd, about 6 days later, the opiates are back.
That's correct, Your Honor. I think that for the 10th, the defendant had just gotten out of jail after being arrested. So there was nothing to indicate that abuse may have been while he was on bond. However, the court is asking to the correct of 17th dilute creatinine as well as the 23rd with the positive opiates. I am aware that there's a prescription that Mr. Starr showed me for hydrocodone that's prescribed to the defendant. However, the date of that prescription that I saw on there, I mean, there's a deep one, April 29th.
April 29th of
2026.
Your Honor, if I may, my client hasn't, well, Mr. Amadeo's client has informed me that he's been receiving the script, if I could approach, for 2 months now. And he can go back and show prior scripts. May I approach?
Yeah.
There's 3 different prescriptions on there.
Okay, I see that, but
the last one is for
this is from the 29th.
Correct. He informed me that he can go back and get those prior scripts. A letter from his doctor as well to show that he's been receiving this now for 2 months. So the
he's getting them filled at Walgreens.
I'm sorry. What was the question?
Does he always get them filled at Walgreens?
Filled at Walgreens. Other places.
There's other places. A little closer.
It varies in terms of the place he picks up his prescription. But he can get a letter from his doctor stating the initial date that he was prescribed hydrocodone.
Well, I think somebody better go find that, because all I have in front of me is a positive test and a prescription after that date. I don't have anything on these indicating.
I didn't have no way when I got out. I had already been taking them, so I don't know, keep this.
And it's interesting also to me that I'll have to see, making sure that I'm saying this right, which would be typical that these aren't refills.
I also think I noticed that, Your Honor.
So,
And it would be the request of the people just to make the record clear that the defendant be remanded at this point and his bond be revoked. This is his third test that he's given. And the two that would have been when he was on bond, neither of them are acceptable or negative. It's also my understanding when someone does an intake with community corrections, they're understanding they understand that people may prescribe things that will come up on their test. And I don't have an indication that I was one time, you let me know that the defendant had that conversation with community corrections. It's oftentimes the case that they will say to the effect of, we are aware this person is prescribed buprenorphine. We're aware that they're prescribed any variety of things that may be positive on the test. The court in this case, I don't know if you've had an opportunity to review the charging documents, but this is a delivery and manufacture case. Okay, so this is a case where we have somebody that's manufacturing or delivering controlled substances, and he's now testing positive for opiates. I'm extremely concerned and would request that bond be revoked, he be remanded.
Your Honor, I'm asking at this time, just for right now, that you not do that. If you could allow me some time to possibly get in contact with his doctor so we can get this squared away. He has a prescription for hydrocodone. That's there. He's informed me.
Prescription, though, is after the date of actually both of these. Actually, the first test and the after the date of all of his testing.
Yes, the prescription that we have right now. That's why I'm asking right now, just for this moment, right now, if you not do that, to allow me to clear this all up. I was just informed about this. It's not my case.
So let me ask this.
And also, too, one more thing. He does not.
Okay, go ahead. Interrupt me.
Okay, I'm sorry.
No, go ahead. What do you want to say?
My client has informed me that he does not have a supervisor, an agent at community corrections.
I was trying to bring him that and tell him, because the warrant came out after I had.
What do you mean he doesn't have one?
He has no one that he goes and speaks with directly.
I paid my money and
so you can speak up. You can speak up.
I just paid my money and drop. I was trying to bring it to anybody's attention, but they said they don't have nobody.
So I'm asking if you could pass this matter and allow me to.
Here's my question. Why does he have these today?
Because he's been trying to inform people that, hey, I'm taking these medications, and which one of them is an opioid. So he brought it to court. He did this. Instead of leaving it at home, he did the smart thing and brought it with him. Instead of
knew he had a positive test.
Yes, because he's been taking opioids. And that's the part where I'm asking if we can pause this matter so I can look further into this, so I can shell this out.
What does Bellinger want to say?
Your Honor, I would so too ask that this matter get passed for a few moments. I do have some information that I can share with the attorney that may or may not be helpful to at least past use of Norcos with the client.
I'm just asking if we can pass this matter for right now. I'm not even asking,
I want to know.
The lawyer's fighting pretty hard for this.
Certainly, Mr. Bellinger, I'll let you talk with counsel, but I'm trying to figure out why did he bring these today and not the previous ones?
It's been my experience, Your Honor. Been doing this now for 11 years. I've come. Yes. Wow. Congratulations, Tro. Yeah.
11 years.
I've come across plenty of clients who say, "Oh, I have
for the time that's like 1/20th of the time Vincent's.
I have a prescription," and then I ask, "Where's the prescription?" "Oh, I left it at home." He brought it with him. He's been trying to get someone to see, "Hey, I have a prescription for these things." He hasn't been able to see anyone at community corrections to show them.
Where's the previous prescription?
That's why I want to look into. That's why I'm saying if we can pass this.
Right now. What I'm trying to figure out is why he didn't bring that one, because this one is problematic because it's all after his testing.
No, I don't have. Oh, you knew. They said they called, but I'm saying for the prayer one, it wasn't on any papers like.
Your Honor,
and none of the
answer your question.
Cocaine. But anyway, go ahead.
But that was, I believe, when he got released. But to answer your question, why did he bring this? Community corrections and called them and informed them, hey, positive test. So he brought that. He brought the current prescription. Again, I've come across plenty of clients who say, I have a prescription. Where is it? I left it at home. I can't find it. He brought something. I'm asking, based off of that something, if I can go and look further into it just for right now. Just for right now.
For how long?
10, 15 minutes.
Okay, then at this point, his bond's revoked. They can take him, and then we'll bring him back out if necessary.
Mayor,
if you want to, but I don't know if you do.
Previous prescription. I didn't have to keep because there wasn't a warrant out for my arrest for this case. So I had no reason to keep it. I wasn't reporting to anybody. So when the warrant came out, that's when I was, you know what I mean? And now I got to start keeping them. But prior to that, I never had a warrant, so I never had to keep them.
Oh, okay. All right. Thank you. Court calls the case, People versus Brandon Peer.
Thoughts for the people?
I don't know yet. I'm going to give him what he's got to do. Go ahead. Brandon Peer.
Good afternoon, Your Honor. Cameron Bill on behalf of Mr. Peer, who appears via Zoom. No objections to proceeding via Zoom this afternoon. Mr. Peer, can you state your name for the record, please?
Brandon Scott Peer.
Thank you. All right, what are we doing?
Your Honor, today's the time and date set for the probable cause conference. I am requesting that this matter be set for an exam. Just need an idea as to what dates the court may have available just to coordinate with
have all the discovery?
I do, Your Honor.
All right. You know, the people have we're setting them on the 19th.
At what time, Your Honor?
Maybe at 9 a.m.
Okay.
People who have their witnesses.
We'll try for that day. Thank you, Your Honor.
Preliminary examination in this matter will be set May 19th, 2026, 9 a.m. That's before Judge Garwood.
Thank you, Your Honor. We'll be there.
Thank you. Bond continued. Is Vincent supposed to be leaving?
Vincent.
Did anybody ask if he was supposed to be going anywhere?
Done. Here anyway. So. He's finished.
All right. We lose him, Bellinger. It's all on you now, man. Court calls the case, People versus Barry Goldstein.
Barry Goldstein.
Good afternoon, Your Honor. Rico Neal, appearing on behalf of Mrs. Goldstein. Mrs. Goldstein, please unmute yourself and state your name for the record.
Mary Jo Goldstein.
Mary.
Okay, thank you. All right, what are we doing?
Judge, the prosecutor and I have discussed this matter. We've been before Your Honor previously. We are attempting to have my client screened for a drug and/or sobriety court. That screening has not taken place as of yet. I understand that the people responsible for that may have been out of town for the past couple of weeks. We're asking for another brief adjournment in this matter so that can be accomplished. Both parties are in agreement.
That's correct. Maybe screen by Ms. Sample with felony drug treatment court.
Oh, the felony drug. Okay, gotcha. Okay. Probable cause conference, June 4th, 2026, 9 a.m. Or as your invite indicates.
Judge, I'm scheduled to start a jury trial on June the 2nd. May I have a different date by chance?
No, I'm kidding.
They'll miss you.
It may or may not go, but we're set to go on the whole case.
Okay, no, I got you. I'll make it June 9th.
All right, that'll work.
I don't know.
Yeah, I'll make it June 9th because I don't want to go further up because if I did I say 9th?
Yes.
11th.
Okay. Thank you, Judge.
June 11th.
June 11th.
All right.
June 11th?
Yeah, June 11th.
June 11th at what time?
At 9 a.m., but you'll get an update. It'll likely be in the afternoon or mid-morning.
Will do, Judge.
All right.
Thank you very
Bond.
much.
You're
Thank you.
welcome.
Have a good day.
You too. Court calls the case, People versus Adam Allen.
Deborah
Schlossel on behalf of the defendant, Mr. Adam Allen. Mr. Allen, please state your name.
Adam John Allen, Senior.
Yep, I can hear you. All right, what are we doing?
Your Honor, at this time, we are still in the process of applying for a specific sobriety court. They have a very rigorous, long application process. So we would respectfully request that this matter be set out for 30 days if you can.
Which sobriety court?
St. Clair Shores.
All right. Without objection, I'll adjourn it June 4th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Michael Shorter.
Deborah Schlossel on behalf of the defendant, Mr. Michael Shorter. Mr. Shorter, please state your name. Mr. Shorter, please unmute and state your name.
Michael Anthony Shorter.
All right. Thank you. What are
Your
we
Honor,
doing?
So at this time, we need to,
Shelley,
I
I
have
think you're
discovery, but we are engaged in plea negotiations and I need to speak with the prosecutor about possible mistaken identity. So we would like to have this matter set out as well.
Charge on this. I'll just go to that June 4th, 2026 date, 9 a.m.
Your Honor, at this time, my client lives out of state. He lives in Texas. He's never been to Michigan. We are asking
He never
for...
has?
No, sir.
Really?
No, sir.
So, Your Honor, we're asking for continued permission for him to live out of state. The magistrate granted that, but I just want to
So
make
if
sure
I said no, if I said no, he'd have to come to the Great Mitten to the north?
I guess so, Your Honor. I'd have to appeal you.
I should make him come up here. Never even visited our state. Huh?
No, sir.
Well, maybe we can take a vacation and go grab it. No.
He's never been to Michigan. Why is...
I have a job.
He's got permission to reside in Texas.
Thank you, Your Honor.
I've never been to Michigan.
All right, thank you.
But how's he charged in Michigan if he's ever been there?
Bond continued.
Why are they
June
doing
4th.
plea negotiations?
Thank you, Your Honor.
Thank you.
You're welcome, sir. Court calls the case, People versus Terry Williams.
Stop. Back that up. I need to hear that one more time.
At this time, we need to, I have discovery, but we are engaged in plea negotiations and I need to speak with the prosecutor about possible mistaken identity. So we would like to have this matter set out as well.
We have discovery, plea negotiations, which means might plead guilty to something.
I'll just go to that June 4th, 2026 date.
Mistaken identity.
9 a.m.
Your Honor, at this time, my client lives out of state. He lives in Texas. He's never been to Michigan. We are asking
He never
for...
has?
No, sir.
Really?
No, sir.
So,
how do you...
Your Honor, we're asking for continued permission for him to live out of state. The magistrate...
How do you pick up a charge
Given the
in
circumstances, I don't know if we're going to have that discovery in a reasonable amount of time. I leave it to the court and defense what they want to do moving.
Well, he wanted to examine last time, but I wanted him to have the discovery. But if it's not there and the police aren't responding to you, then they're going to have to deal with it some other way. I'm ready to set it for exam given those circumstances. I don't know. What do you want to do, Mr. North?
I'm ready to set it for exam, but I mean, as long as if there is a video, and that they end up getting, I would like to see it, of course, but I don't have a problem setting it for exam.
All right, I'm going to set it for a preliminary examination. I won't say discovery. Discovery is complete with the exception of that video if it exists, but with the police agency not responding, that's the problem. And people will need to have their witnesses available on the 19th. I'm going to set this matter for May 19th, 2026, 9 a.m. That is before me.
Before me.
Your Honor, unfortunately, I can't do that day. I'm already in
26.
26. Yes, the 26th. Yes, absolutely.
You can do the 26th?
Yes, Your Honor.
Then I'm setting it for May 26, 2026, 9 a.m. That's still before me.
Still before
Thank you, Judge.
You can't get away from me.
All right. Thank you. And then we'll talk about why PD not calling my prosecutor back, Mr. Cook. This disrespect. No, I'm taking it as a personal affront, Mr. Cook. Just saying. Court closing case. People versus Lamar Hampton.
National Health for the People.
Hi, Judge Wade Fink on behalf of Mr. Hampton. I know I saw his name, Mr. Hampton. If you could turn your video on and unmute and state your name.
Lamar Hampton.
Thank you.
Your Honor, two things. One, I've received pages 22 through 40 of discovery. I was late in getting to Ms. Feltis to check if that was everything. Sorry.
What are the first 21 pages?
That's what I'm inquiring if that is something else or if it started there, and I should have gotten to Ms. Feltis sooner, so I apologize. But I wanted to ask number one if discovery was complete, and then number two, tell you about scheduling.
You what?
I was going to ask you about scheduling, tell you about what I proposed, depending on if discovery is complete. I didn't know if it was.
Okay. So, Ms. Feltes, pages 1 through 21, do they exist? Okay. No, that's a fair answer.
Well, I didn't hear the answer, Judge. What was it?
I don't know.
I don't think he's preparing for himself.
He said she's not sure.
That's a fair answer.
I'm so sorry. I don't have the answers for me today, but I will work on this.
All right. So the second part, now that we know that we don't know. What do you want me to do with the case?
Your Honor, forgive me for this request, but I'd like to stay married. I'm supposed to be out of town from May 23rd to June 3rd. If we could have that June 4th date, I'd be grateful.
Said though that she didn't care.
Oh, well, please, I do not want to go.
I'm kidding.
I do not want to go to this wedding. So please, I hope that's true.
Wow. And now everybody in the world knows.
I'll scream it from the rooftops.
So what days are you unavailable, sir?
Would you be able to give us that June 4th date as a PCC judge?
Absolutely. I don't have a problem. Probable cause conference, June 4th, 2026, 9 a.m. He wants to stay married.
You're the man. Thanks, Judge.
Fine, continued.
I have a sneaking suspicion that it may have been created as a discovery packet and then discarded as a new one made. So that might be why we have different dates.
I should have asked you sooner, Ashley. I'm sorry. I'll call you.
All right. Thank you. Bond continued. Court calls the case, People versus Cyrus Roberts.
Alexander, on behalf of
Good afternoon, Your Honor. Tia Brock on behalf of Mr. Robertson. Mr. Robertson, please unmute and state your full name for the record.
Attorney Tia, twirling her hair.
Cyrus Robertson.
Thank you.
Coming to you from the
future. What are we doing today?
Judge, I'll be looking for an exam date on this one.
All right. You have all the discovery?
I think so. I believe so.
Thought she was twirling
People
her hair.
have their witnesses available the 19th. Preliminary examination will be set May 19th, 2026, 9 a.m. before me.
Bond will continue.
Perfect. Thank you, Your Honor. Have a good day.
Perfect.
Thank you. You too. Court calls the case, People versus Joshua Wara.
And Judge Lawrence H. Margolis Whitman on behalf of Mr. Wara, who is approaching. Josh, please state your name for the judge. Joshua Wara.
Got a polo shirt on.
Legislative date and time set for a pretrial. We have reached an agreement. Mr. Wara has been gone over his advice of rights,
he didn't have any.
What is this count to? I can't read this.
That would be my handwriting.
Yes, I know.
Student actually. She causing serious.
Got it. 93-day offense. All right. So the plea form indicates that he's going to plead guilty to that charge. Upon a successful plea to that charge, count 1 would be dismissed, and that's the court's full understanding of the agreement. Is that correct, counsel?
Correct, Judge.
That's perfect.
Okay, have him sworn.
Raise your right hand. Testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor. Joshua Wara. All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of committing a moving violation causing serious impairment. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that? Yes, Your Honor. All right. You also understand that while I'm taking your plea, Mr. Wara, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that? Yes, Your Honor. All right. Still wish to plead guilty? Yes, Your Honor. All right. And to that charge, how do you plead? Guilty. And you understand that by pleading guilty, you'll not have a trial of any kind? Yes. All right. You signed an advice of rights form, correct? Yes. Any question regarding any of those rights? No, Your Honor. All right. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights of it? Yes, Your Honor. You understand you're giving up your right to appeal of right? Yes. Are you on probation or parole? Yes. Were you on probation or parole at the time of this? Yes, Your Honor. All right. You're on probation? Parole. You're on parole? Yes, Your Honor. All right. You understand that this could be a violation of your parole? Yes, Your Honor. You understand that if it is considered a violation, you could be sent back to do the remainder of your term? Yes, Your Honor. All right. You still wish to plead guilty to this charge? Your Honor. Anybody promise you anything other than what's been stated here today to get you to plead? No. Anybody threaten you or coerce you in any way? No. You're doing this voluntarily and of your own free will? Yes, Your Honor. And also because you believe that you are indeed guilty of this offense? Sure. Okay. October 15, 2025, at the location of South Main Street near East William Street, City of Ann Arbor, Washtenaw County, State of Michigan, were you operating a motor vehicle? Yes, Your Honor. All right. What happened? I went through a light. We intercrossed the lights and, yep. Say again? I went through a light. Okay, you ran a red light? No, I didn't run a red light. I went through the light and had another car. But it wasn't red.
What?
It was green.
It was green for me? Okay, whoa.
So you had a green light? Yes.
I can take it.
And you hit another car? Yes. Okay, so at the point you did that, what moving violation do you think you were committing? I think I might have been speeding, to be honest. Pardon? I think I was speeding, to be honest. Okay, so do you know you were speeding? It was, yes. Pardon? Yes. Okay. So just because that's why I had to make sure I got it right. You went through an intersection and you were speeding. Yes. And because of that speeding, that caused an accident. Yes. All right. And did that accident cause this other person to cause some bodily impairment? Yes. What do you know what happened? No, but I broke his arm. Broke his arm? Correct. All right. And you're not disputing that? No. Okay. All right.
Did he rear end?
Joshua, if I accept your plea, if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that? Correct, Your Honor. Okay. Counsel, are you aware of any other promises, threats, or other inducements
No, Judge.
And have I complied with the court?
Yes, Your Honor.
You have.
All right, court will accept the defendant's plea of guilty to count 2.
I
Count
need
1
somebody
is
to draw a
dismissed.
diagram.
Pre-sentence
Maybe
investigation
Hot
and
Wheels cars,
report
the whole
is
thing.
ordered at 15th District Court probation. Sentencing will be
29th at 8:30.
May 29th, 2026, 8:30 before Judge Perry.
May we be heard on bond, Judge?
Yes.
Briefly.
Your Honor may recall you
allowed Josh to be released from custody. He had been in for several months. You allowed him to be released from custody. He went through a brief hospitalization period and then placed him on home confinement with an individual named Tammy Witherspoon. We are seeking to modify the condition of the home confinement so Mr. Wara can live with a different person, a different place of house arrest. Janet Cutts, can you stand up, ma'am? The individual with the phone issue earlier lives in Ypsilanti. She lives at 1165 East Cross Street.
Whoa.
She's willing to be his custodian, accept rent from him. It's a sober house, I'm advised. And that's where Mr. Wara is hoping to be able to go to. And I brought her to court in case you had any questions for her. I don't believe.
I think he needs glasses.
As long as he's on that tether somewhere, I don't care where exactly he's tethered to. So I have no change the address.
Yeah, that's fine.
Thank you, Judge.
I'll just need a written order because this is files going over that way to.
Of course. There were a couple other points I wanted to. The first order that Your Honor had signed, it talked about Josh being able to get medical and mental health treatment, but I think I put the word necessary in there. So he's been wanting to go to AA, NA meetings, and his tether agent said that we would have to, that's not, yes, his tether agent said that we would need to get that modified for him to be able to attend those meetings. Like he wouldn't let Josh go to those because it's not emergency mental health treatment.
So it's AA meetings and NA meetings?
Well, I'm seeking for AA, NA, moving the house to the new place. His grandmother is dementia-ridden and at Chelsea Hospital. She's not going to live much longer. We want to be able to see her. He has actually set up some job interviews at fast food restaurants. So there's a couple things that I provided some of this to the people, and Mr. Cook has stipulated to everything except for the work issue. And the last one, Judge, and I could have approached and I apologize. The last one is he has a medical marijuana card, and he wants to be able to use marijuana.
Yeah.
You stipulate to everything except the work.
I was
And the
unaware
marijuana.
of the work
And the
until
marijuana.
today.
And the marijuana.
As long as there's specific dates and times that he can put and give to community corrections for when he'll be working, where I have no issue with that exception there. And regarding the medical marijuana, I believe that
I'm going to leave that up to Judge Perry.
Sounds good, Judge.
So I'm not going to do that. What I'm going to do is you guys give me an order regarding everything else you agree to. I don't mind signing off on that. But in terms of the medical marijuana, deal with Judge Perry on that.
All right.
All right.
Thank you, Judge.
Thank you.
Always a pleasure.
So we're going to take care of yourself.
Sure.
All right. You're looking a whole lot better, fella. Huh? Okay. Court calls the case. People versus Lisa Keebler.
John Shea, working on behalf of Ms. Keebler, who is approaching.
He's got quite a jacket there.
Can you say your name for the record?
Lisa Keebler.
Thank you.
Thank you. Your Honor, Ms. Feltz and I discussed this previously with you last time we were here. Potential resolution that would involve various treatment type options, which I'm still investigating. I found possibly a specialty court that would be more appropriate than what we discussed last time. I'm still looking at it. I'll be discussing it with the people once that's done. So I'm asking for a 2-week adjournment and hopefully have some more firm information. But
all right. I'll adjourn the matter then to May 21st, 2026, 9 a.m. Bond will, council approach. Bob.
All right, sorry, I'm talking to Mrs. RA real quick. Who brought me lunch, by the way. She brought me lunch. It's a, well, it's like a shredded beef and peppers on sandwich. It's not a Philly cheesesteak, but it's close. Let's see. Got something back in McBurney's court real quick.
Of Darrell Wilson. She's on the call. She would like to make a statement. However, from what I've gathered, Mr. Wilson, who was the person in the middle back seat, he cannot talk, cannot walk. He has a brain injury. He has a feeding tube. He's kind of bedridden. He goes back and forth to the hospital because sometimes he gets infections from sitting too long. And I'll let his mother in this case talk a little bit more about those injuries. The state did try to reach out to the next of kin for a boss meeting. However, we were not able to reach anyone, but we did get a chance to look over those medical records. And Mr. Newton, I believe all of his teeth were knocked out. He does have a brain injury and had a couple of fractured and broken ribs and bones in his body.
Whoa.
So we weren't able to get an updated how is Mr. Newton doing in this case because we could not find next of kin. However, Ms. Wilson's mother is on the call and would like to talk about kind of how Mr. Wilson's life has been since this injury.
Okay, and I'll hear from her in just a moment. The indictment in count 2 says that the particularly serious situation for Mr. Newton was something about his leg. So some of the bones that were broken were in his leg. You mentioned his teeth got knocked out, but I'm assuming there's evidence that something happened to his leg.
Yes, Judge. The medical records are, of course, very long, but those some of the bones that were broken were throughout his body, but in his leg also.
Okay, got it. All right. So on the call, there is a Jada's iPhone, and then there is a Treese. I may not be pronouncing that correctly. I'm not sure which is Mr. Wilson's mom.
It's Treese, it's me.
Hey, are you Ms. Wilson? What's your last name?
Thompson. My name is Latricia Thompson.
Ms. Thompson, I appreciate you joining us. Let me add you to the screen here so that everyone can see you. So you are Darrell Wilson's mother?
Yes, sir.
Okay. Well, I appreciate you joining us, and I am sorry what has happened to your family. We're almost 3 years into this, so
we're going to rewind here. Hang on. This seems pretty extreme.
Are you ready?
I'm not sure if it's DUI or some sort of racing crash or something.
Then we're going to get on the record. It's position 27 on the calendar, 25 SC 006827, State versus Preston Cobb. Good afternoon, Mr. Cobb.
Good afternoon, Judge.
Mr. Cobb is in court with his lawyer, Ms. Rios. He is charged with 2 counts of serious injury by vehicle and 1 count of theft by receiving stolen property. At least that's what it says on the calendar. And Ms. Smith, representing the state, is going to start our plea conversation in just a moment. She'll put you under oath, and then you will be asked a bunch of questions you've already heard several times today, but it's your turn to answer the way you think is the correct answer. You need to make sure that you stop us if at any point you've got a question. If you're not following what's going on, or you just need a minute with Ms. Rios, will you let me know that?
Yes, sir.
Okay, then let's start.
Mr. Cobb, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Preston Cobb.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 20 years old and I graduated high school last year of May, 2025.
Where'd you go to high school?
North Clayton High School in College Park.
Got it.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Cobb, do you remember being arrested on these charges?
Yes, I remember being arrested.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No, ma'am.
Do you understand that this is a non-negotiated or blind plea and that the state would recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am, I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Cobb, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 25 SC 006827, how do you plead to count 1, serious injury by vehicle, count 2, serious injury by vehicle, and count 3, theft by receiving stolen property?
Yeah, it's guilty.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right. Thank you, Mr. Cobb. Your Honor, if this case were to proceed to trial, the state would show that on...
Is Mr. Cobb pursuing this as a first offender?
Yes, Your Honor.
Okay, I'll cover that with him. Is that something the state is opposing, is neutral on, or what's your view on first offender?
Leaving the court's discretion.
Okay, we'll get to that. You were going to tell me about the facts of the case.
Yes, Judge. On June 18th, 2023, officers of the South Fulton Police Department responded to 2929, I'm going to spell it, BETHESDA Road. It's in Atlanta, Georgia, and also Fulton County. When the officers got there, they saw that a car had crashed into a tree, and that there were passengers inside of the car that were injured. The officers that responded, also EMS responded. They were able to take the passengers out of the car. All of them were kind of banged up, so they all went to Grady to be treated. In this case, the officers, after doing their investigation, found out that the defendant in this case, Mr. Cobb, was the one who was driving the car at a high speed before it hit a tree. The car that he was driving was a 2019 Kia Optima. It was stolen, and the person who owned that car, the officers got in touch with her, and she said she never gave her car away. She didn't know who Mr. Cobb was, and that she had reported it stolen. So the car that was used in this offense was stolen. The officers were able to get a black box from that Kia Optima that showed that 2.5 seconds before the crash, the car was going 122 miles an hour. At the time the car hit the tree, it was going 88 miles per hour. So the car was going pretty fast.
There's no way a Kia
in this
can go
case, there were
122.
4 other passengers in the car, not including the defendant in this case. However, 2 passengers in particular they had pretty serious injuries. One of those victims being Darrell Wilson and the other person being Boss Newton. In this case, all passengers were transported to Grady Hospital, but their stays were a bit longer because of the injuries that they had. Because of this, the officers were able to determine that because the defendant in this case was the one that was driving and that it was a stolen vehicle, warrants were taken out and he was arrested for these charges that we have before us. Those are the facts of the case, all occurring in Fulton County. Regarding the recommendation from the state in this case, for counts 1 and 2, the state is asking for a 10 serve 5 with the balance probated. And regarding count 3, we're just asking for 5 to serve to run concurrent with the 10 serve 5 recommendation in counts 1 and 2. Regarding the special conditions of probation, we're just asking that the defendant have no contact with either of the victims, to complete an anti-theft course, to complete a defensive driving course, and also that was the last thing for the special conditions of probation. The state in this case did reach out to both of the victims. At the time, they were, I want to say juveniles. Right now, they're still young, maybe around 19, 20. But I was able to speak with the mom of Darrell Wilson. She's on the call. She would like to make a statement. However, from what I've gathered, Mr. Wilson, who was the person in the middle back seat, he cannot talk, cannot walk. He has a brain injury. He has a feeding tube. He's kind of bedridden. He goes back and forth to the hospital because sometimes he gets infections from sitting too long. And I'll let his mother in this case talk a little bit more about those injuries. The state did try to reach out to the next of kin for Boss Newton. However, we were not able to reach anyone, but we did get a chance to look over those medical records. And Mr. Newton, I believe all of his teeth were knocked out. He does have a brain injury and had a couple of fractured and broken ribs and bones in his body. So we weren't able to get an updated how is Mr. Newton doing in this case because we could not find next of kin. However, Ms. Wilson's mother is on the call and would like to talk about kind of how Mr. Wilson's life has been since this injury.
Okay, and I'll hear from her in just a moment. The indictment in count 2 says that the particularly serious situation for Mr. Newton was something about his leg. So some of the bones that were broken were in his leg. You mentioned his teeth got knocked out, but I'm assuming there's evidence that something happened to
Why are we
his
getting
leg.
weird audio?
Yes, Judge. The medical records are, of course, very long, but some of the bones that were broken were throughout his body, but in his leg also.
Okay, got it. All right. So on the call, there is a Jada's iPhone, and then there is a Treese. I may not be pronouncing that correctly. I'm not sure which is Mr. Wilson's mom.
It's Treese, it's me.
Hey, are you Ms. Wilson? What's your last name?
Thompson. My name is Latricia Thompson.
Ms. Thompson, I appreciate you joining us. Let me add you to the screen here so that everyone can see you. So you are Darrell Wilson's mother?
Yes, sir.
Okay. Well, I appreciate you joining us, and I am sorry what has happened to your family. We are almost 3 years into this, so whatever your son is having to deal with if it's still going on, it sounds like tragically it's a permanent situation. Why don't you let me know how he's doing, how you're doing, and how this situation has impacted your family?
It's impacted us a lot, like, cause it changed everything. Now Darrell had to have 24-hour care with skilled nursing and unskilled nursing. His body contract like a baby fetus, so he can't stretch his legs out, and he can't stretch his hands out, or his hands balled up. But I wish Darrell were here, but he had to go to the hospital emergency room because he was having a urinary tract, which he catched them throughout the whole 3 years. He been catching them back to back, so he had to go to the emergency room. So they changed his tubes and stuff like that. But he nonverbal. I wish Darrell was here so y'all could see him. I'm not mad at Preston. Only thing I just want to know, Preston, like, if them church asked you to stop, why you just didn't stop, baby? Because you changed everything. I don't want to see you go to jail, none of that. I don't want to see, like, this going on with my son, but at the end of the day, like, they asked you to stop. That's the only thing that I just don't understand. If them boys asked you to stop, why you didn't stop? Because Darrell didn't know none of y'all. He only know the boss. Boss introduced Darrell to them. And Darrell didn't go to school with you all. We had just moved to the neighborhood. We were new to the neighborhood, and he got the worst out of everything. And it just changed a lot. So, I don't...
Do you know, Ms. Thompson, you mentioned that your son knew Boss Newton. Do you know how Boss Newton is doing? Do you have any information on how he's doing?
No, the last time I talked to them, it's been like a year ago, and he was at home and stuff. You know, he walked with a limp. He missing like his top and his bottom teeth, and that's about it. But he was functioning, talking well.
Okay.
Darrell the only one got the worst end.
Got it. Do you know anything about what happened? There were apparently two other young men in the car besides your son and Boss Newton and Mr. Cobb. Do you know anything about what happened to the other young men?
No, sir. I only seen all them two. I only seen them when Darrell was in the hospital.
Yeah.
We didn't even know. I thought it was some boys that he normally hang around. I didn't never know them. He ain't never go to school with them. Darrell, that was the first time meeting them.
Okay. And how is it that your household is able to afford 24-hour care? That sounds very expensive.
Yeah, through Medicaid. He received Medicaid. Medicaid helped us out.
Okay. Well, I'm glad that resource is there for you all, and I'm grateful.
I don't know. It ruined Mr. Because he ain't in the hospital, but if I turn, y'all can see he got a whole hospital bed. Like, feed it to, he stay on medicine.
Oh, yeah.
This him.
Okay.
He was in rehab, but he got a whole hospital bed.
Okay. Well, I'm glad that you've been able to care for him, and I hope you have help. It's not just you. I know you said that there's in-home nursing. Are there others in your household who can help?
His sisters, he got siblings.
Okay.
He got siblings.
Okay. Well, Ms. Thompson, it's been real helpful to hear from you, and our thoughts are all with Darrell. This isn't the kind of thing he's going to recover from. So like you said, it's life-changing for him. And here's Mr. Cobb standing in court. So it was a very different outcome for different people.
Yes. I just wish he would have stopped when the boys told.
Yep, I bet he does too. Well, you're welcome to stay on the call while we go through the rest of this, but thank you for being here.
Okay, you're welcome. Thank you.
Man.
All right, Ms. Smith-Mann, any criminal history information for Mr. Cobb?
Yes, Your Honor. There are 3 prior cycles that are not included in the cycle that is before you today. There is a 2024 battery against a female who is pregnant in Clayton County. School, and it's Clayton County School Police to be exact. There is a 2026 Clayton County theft by receiving stolen property, willful obstruction by law enforcement officers, driving without a valid license. Nothing further, Your Honor.
All right, you said there were 3 cycles, and you told me a battery against a pregnant female. That sounds bad. And then very recently, driving without a license while you are awaiting resolution of a serious injury by vehicle case. But those were 2 cycles. What's the third?
The third cycle was a willful obstruction that was dismissed, a theft by receiving stolen property that was dismissed from Clayton County in 2023.
Got it. All right. Thank you.
You're welcome, Your
Somebody's got
Honor.
their hand up and back.
Ms. Rios.
Yes, Your Honor. I want to start with having Mr. Davis talk first about the next level.
Okay. Hello again, sir.
Well,
how are you?
Good, thank you.
We have taken up a lot of your time today. I apologize. You've been very patient, and hopefully you've been able to attend to other things. You should cover whatever you want. You know, I'm familiar with the amazing work you and your program do. So I don't need to hear so much about that. I'm more interested in what you know, if you know anything yet about Mr. Cobb. He's in a real awkward situation right now.
Yes, just hearing the past, just so unfortunate, you know, just my heart goes out to his family just to happen to just have a sudden change. These are a little different than me coming in front of them. Normally it's kind of straight to the point, but you know, I've had an opportunity. This young man has been in the program now. His attorney reached out, but I have some history with him. Some years ago, maybe when he was like 12 or 13, his family was bringing him on a preventive measure. He never had any type of trouble. They was brought into it. I think he came by way of someone from the church, and we really liked him. So it was a loss of contact. I don't know if it was a transportation issue, something like that. But you know, I often try to, especially when I come in front of you, I try to explain. I'm sure you hear this all the time. How do we get here? Like, what is the codependency? How do you end up in a vehicle, whatever? And I'm sure 90% of the people that come before you, Judge, have some type of family dynamics that leads to this. This young man here, he lost his father the weekend of his 8th grade graduation. He did begin to live with his grandmother and help care for her. And shortly after losing his father, he loses his grandmother. So he has all this trauma, all this depression, all this grief that's on top of all that. And I just think that at that time is he began to reach and search and try to find somewhat another family. And just the unfortunate situation. And
they turned to gangs?
Yeah, so he's been in the program, he's doing well. I just really wish that had I known, I was really wished that the family would have been able to keep him with us. But I always just try to give them credit because they try to get ahead of it. And I think when he lost his father and all that, they just wanted to get ahead of it. But again, it's so unfortunate. Great young man. He's been accepted to the program. You know the rest, how we work close with the courts. And should you grant him this opportunity, the relationship that we have with the courts and probation, that we would, even if we had to do some additional things to hold him accountable. But I just got a chance to get to know the family over the years. It's just so unfortunate. He's an amazing young man. So that's all I have to say.
All right. Well, I appreciate you being here again, and thank you for the work that you do.
Thank you, sir.
One life at a time.
Yes, sir.
Ms. Rios.
Yes, Your Honor. In regards to this situation, this happened 3 years ago. At the time, he had just turned 18 years old. The friends that he were in the car with that are the victims in the case, they picked him up. It's basically a joyriding situation. They went to one of the friends' house, hung out, and they got back in the car with Mr. Cobb being the driver, and there was music playing. They were being rowdy teenagers, and mistakes were made. And they were very, very big mistakes that he regrets, and he's very remorseful of the situation. He also, he was even arrested for a while after the situation because he was also in the hospital. I know his injuries are not comparable to what the victims in the case are dealing with, but he had also a traumatic brain injury that he still suffers from, that's affected his intellectual ability. And he's ongoing seeing a doctor for that. He had other injuries with his leg, broken leg, collapsed lungs. So he was in the hospital for months and months, also dealing with the injury he just made. He has made a decent recovery, but is still suffering from that. As you know, 18-year-old brains not developed, not making the best decision, and unfortunately just had very bad consequences for everyone involved in the situation. So far, he's been trying to do well. He's now 20 years old. He graduated from high school. He has one daughter who turns 2 in July. He's employed. He's working at Amazon, preparing customer service orders. He's been trying to take care of his child and help out his mom and do good. I do understand the seriousness of what happened and how this has had very serious effects for the victims in this case. I just don't believe him going to prison for 5 years serves anyone. We heard the mother of the victim in the case that she doesn't even think that he should go to prison. I get the serious.
I do. I think he should.
Yeah, I do too. Hey, both you stop, Dad. You'll get a chance. It's not your turn right now, so let's not interrupt.
Whoa.
All right.
This wasn't a malicious, intentional act. It was a thoughtless and an act of someone who did not have a fully developed brain at the time, being that he was a teenager. I'm asking for, on count 1 and 2, the theft by receiving to be 10 years on probation, with the 5 years to serve on the back end and to suspend if he has no further convictions. And on count 1 and 2, and then count 3, the same sentence with if he doesn't have any trouble for those 10 years, for the 5 years in prison to be suspended, and for him to be treated as a first offender.
Okay, so first offender I get, and we'll cover that, but you're asking for one of these backloaded sentences where if Mr. Cobb over the next 5 years makes good choices and stays out of trouble and whatnot, then that would be evidence that he has turned a corner, and the remaining 5 years would be a sentence, but they would not be custodial. They'd be suspended so that if something happened year 6, one could still deal with it, but he's not in custody.
Yes, Your Honor.
Okay. So I'm gonna come to you in a minute, Mr. Cobb. Ms. Smith, I believe Darrell Wilson's father is now on. I don't know if you were expecting him. I'm happy to hear from him as well. He kind of barged in while Ms. Rios was talking. Is that someone you've had contact with as well?
I spoke with Mom. She said that other family members may want to speak, including his dad. So
okay. All right, Mr. Wilson, if you want to unmute, if there's something you want to share with me, I would like to hear from you now.
Yes, sir. How you doing today?
Well, I'm all right. This is a pretty sad situation that we're working through. I got to hear a lot about how your son's doing from his mom, and that was hard to hear.
Right. Well, I think he should get whatever Matt sent him because, my son did ask him to let him out the car. My son asked him to let him out the car, and he refused to let my son out the car. You know what I'm saying? And so that's one thing. And, I don't know what my son experienced doing that, but it's been a bad experience for me and his mom and his family and the rest of our family. My son almost died twice. We've been dealing with more than enough. Still to this day, we back and forth to the hospital and, all that. So, I ain't trying to go ain't trying to, keep y'all alone, but I think he should be getting like way more than house arrest. Cause my son, what I'm saying, was, technically on the right path. They went all doing right, but my son didn't want to take that ride. And he made my son take that ride. So I don't think he should be getting no light sentence and none of that.
Okay, I appreciate that. I appreciate you joining us. I understand your perspective on this, and I am glad that your son has both you and his mom in his life trying to help him work through all this.
Right.
All right. Thank you for being here.
Okay.
Ms. Smith, both Mr. Wilson's mother and his father have, they've echoed each other that they believe at some point the passengers were saying either slow down or let me out. Is there something in the body of evidence you have about that, or is that something that Mr. Wilson's parents would know because somehow he was able to communicate that to them?
So during the officer's investigation, one of the passengers in the car that was not severely injured told other family members that they asked him to stop and they asked him to slow down, but he refused. He went fast and he could have music. But that's not something that the passenger said directly to officers. However, during their investigation, that is something that they became privy to.
Okay, so you've heard that theme as well. You're not hearing it for the first time from Ms. Thompson or Mr. Wilson.
That's correct.
Okay.
Excuse me, Mr. Young, sir. Me and his mom actually visited him while he was in his coma, and he said that himself, while he was in his coma, he said Darrell asked me to let him out before he even put the car in drive. My son asked him to let him out the car. I don't know about nobody else, but he said that I hear on mouth that my son asked him to let him out the car off the rip. Cause my son, no, I don't even, he know better. So, yeah. I don't know what they communicate. My son couldn't communicate with the officer.
Right.
And Preston was the one that came to pick the boys up. Them boys didn't have no car. Preston was the one that came and picked them up. His mama had a video, but she deleted the video of him telling the story that them boys told him to stop. He said that himself when he was in the hospital, because it wasn't nothing wrong with Preston. Preston, like he functioning now, he was functioning then. I ain't never known about a brain injury. His mama, she stayed by my baby bedside because she thought my son was gonna die. She the one called me and told me what was going on. I didn't even know that my son had been in an accident until Preston mom called.
All right. Well, I'm glad she called you. Okay. All right. Thank you both. Ms. Rios, I'm going to ask Mr. Cobb in just a minute if there's anything he wants to add, but I wanted to come back to you because we've been a little dynamic here in our exchange.
I want to make sure his mom, she thinks she want to say something. And I also do have documentation from a doctor about his brain injuries.
Okay.
Severe.
All right. Well, what order would you like to go? Mr. Cobb, are you going to say, you don't have to say anything at all, but you have an opportunity to if you want to. You do want to say something? Yes. All right. Should we have your mom go first?
All right. I really want to just give my input on this case because, like I said, this is an unfortunate situation.
Okay. We need to start first with your name.
Oh, Brenda Cobb.
You're Miss Cobb. All right, Miss Cobb. And you are Preston Cobb's mother. Thank you for being here. It's good for him that you're here. I do want to hear from you. This isn't he said, she said time to say, oh, those Wilson parents don't know what they're talking about. That's not going to help your son right now. But I do want to hear from you about your son, because of course the part I'm focused on is the terrible decision he made that night. And I know he's more than that. He's been alive for 20 years, so there's good in there as well. And so if you want to tell me about that, I'd love to hear about it. I heard some already, but you are uniquely positioned to help me understand that Mr. Cobb is more than a kamikaze driver in June of 2023. Whenever you're ready.
All right, so since this incident happened, it has impacted Preston. Preston, of course, all of them were in the hospital. Of course, I reached out to the family because no one could contact them. And the officer that was on the case said, hey, this is their address, because no one could contact the family, you know, or whatever. So I ended up getting the address and knew where that was, which was near my house. And I was able to go to the door and, you know, hey, you know, it was hard for me to go to somebody and say, hey, your son has been in an accident, but hard for them to ask, well, what happened? Who did it? You know what I'm saying? And, you know, it's hurtful for me because everybody's life has been impacted. You know what I'm saying? You know, his life has changed forever. Everybody's life has changed forever. Even when we was in the hospital, I was by their side because I felt their pain. Even though my son was on one level up, I was down there on their level too, because it was I felt it was my duty to be there for everybody. And Preston did go through, he was in a coma too. He couldn't speak, you know. He still today, you know, has issues remembering things. I have to coach him. You know, I have to pretty much baby him, but he's in a form where he can move. So it has impacted him as well. You know, no parent would think that they will go through something like this because I didn't raise Preston. He didn't grow up in a household to hang with the wrong people. You know, I didn't raise him. I've always coached him to make the right decisions. And unfortunately, it happened. He's accepted, and he's accepted what he did was, you know, wrong by getting behind the wheel. But Preston he was picked up from my house. It was on camera. He was picked up, and that was given, all that information was given to the officer. And, you know, what happened after him getting behind the wheel or what made it happen, I wasn't there. I don't know what played a role in or what was going on in the car. You know, he don't even remember what happened still to this day. He just know I blacked out. We don't know.
Your son was talking in his coma.
Mr. Wilson, I'm gonna have to have you drop from the call if you keep interrupting, okay?
And, you know, it is an unfortunate situation. But since, you know, Preston, he didn't just get out of the hospital and come home. He left the hospital after being there for a period of time. He had to go to the Shepherd Center. He had to learn how to re-walk. It's a lot of things he had to do. And then when he came home, he had to come in, a nurse come in and look after him while I was at work, and still me having to take him to physical therapy. So it wasn't you know, I got out and he you know what I'm saying? He had to go through some things as well. But, you know, since it has happened, you know, Preston has stayed out of trouble. He has finished high school. He has maintained employment for the past 3 years. So that just, you know, right there speaks level, because he could have had this and continue getting in trouble. You know what I'm saying? And, you know, I just, you know, want to say to the family, I'm sorry that happened, because, you know, we never expected this, you know. We never expected this. We, as parents, we can coach our children and, you know, hope they do the right things. But, you know, I'm not here to put the blame on nobody's child, because all my kids made a bad decision, and that, unfortunately, it has changed everybody's life, regardless of what condition somebody in. But I know that whatever happened that night, it wasn't nothing intentional. It's just that it was a bad decision. Because I could be on the other end and be trying to understand why, but I can't ask myself why. But he has accepted that I did wrong, and I never should have, you know, I should have listened, because it goes from not listening. So, you know, that's all I want to say.
Do you know, Ms. Cobb, how any of the other young men are doing? I don't know if any of those kids, they were kids then, were closer to your son, and so you might have a connection through those families, so you could say, yes, one kid, there were no injuries, another kid, he lost his left leg, or...
Well, as far as who he was hanging with, these wasn't Preston's friends. It was just, hey, I think three of the other ones, they went to the same high school, and then, like I said, I don't know, Preston didn't know Darrell, but it's more like someone knew someone else.
Right, Boss knew Darrell, and he brought Darrell along. And my question isn't who knows whom so much as if you are aware of how the other young men are doing. I know how Darrell is not doing, which is not well at all. And we heard a little bit about Boss Newton. There were some issues, but the prosecution team couldn't track down his family.
Right, as far as, I don't know their condition because, from the hospital, there was some, situations where I had to, step back and just for legal purposes, step back because it was more of other issues going on, and let's focus on what's at hand, our children's well-being. But, I just know what injuries they sustained because my insurance, had to deal with me and, compensate Darrell and the other three. But as far as how they are doing, it was just, I need to step back and, just like he couldn't have me contact, I needed to do the same.
Okay, got it. Well, I appreciate you being here for your son. It's a good sign for him. He's got family behind him. I know you're not the only one here for him. Thank you.
Thank you.
Ms. Rios, anyone else besides Mr. Cobb?
Do you want to speak? I'm sorry, I think his other grandmother, Ms. Jones wants to speak.
Good afternoon, Your Honor. Jones.
Hello, Ms. Jones. Tell me your connection to Mr. Cobb. Your grandma. Okay. What do you want to share with me?
That Preston, unfortunately, just stay in tune with what has been said. Preston has never been a bad kid. He's always been a kid that pretty much listen to what we tell him to do. And, it's just,
Mom says he doesn't
when
listen.
kids get together, they have a tendency to make bad decisions. And that was one of the ones he made. And it wasn't because he was trying to be ruthless or trying to be out of pocket. My mind is running.
That's okay. I know what you're saying. This isn't a situation where he said, I'm going to get these guys and I'm going to drive a car into a tree. That doesn't make sense because, of course, he was in the car. And so he was just as at risk of going through the windshield and dying as anyone else.
And my heart do go out to the family tremendously. We are very, very hurt that the family have to endure this. But, it wasn't something that was set out for revenge or any type of malice whatsoever. And, we just want them to understand that, we don't want for their child to be suffering, just like we don't want our child to suffer as well. And, even if he had to do community service some kind of way for that, to attain that, we do mean well for their child. And we mean well for Preston as well. And we just like for them to just take another breath and just say, hey, that was an intention.
I hear you. And it's not their job to forgive. They may get to that point, but that's not their role. Their role is to lift up their son, and they're trying to do that. And it is for them, I think, going to be a forever issue. It doesn't sound like, I'm not a doctor, but it doesn't sound like Darrell is going to suddenly wake up one day and be able to uncurl his hands and move his legs again. So I hope that the family is able to move forward, but I also hear you loud and clear that this isn't one of those cases where there is the bad guy who was out to get other people. That would be maybe if he pushed the car off a cliff with the other people in it, and he wasn't, and that wasn't this case. Okay. Thank you for being here.
Thank you, sir.
Mr. Cobb, it is your turn if there's anything that you want to say. But like I said, you're not required to say anything at all.
I just want to say I'm fully sorry for what happened that day. And like I said, I didn't do it intentionally. I never told nobody they couldn't get out of the car or nothing. It was like we was all in the car. Everybody was jumping around. We was just, I guess we were just being lit at the time, and then everything happened. But ever since that day, like, you know, I distance myself from that type of people. These was people that stayed in my neighborhood. We all clicked up, and I just wanted to fit in with them because what I thought was cool, what they was already doing, I thought it was cool. I started getting mixed up with it, but I tried my hardest to stay away from situations that I know will put me back in the place I'm in now.
Talk to me a little bit. I don't want you to tell me facts about it because it may be an open case, but it sounds like just a couple months ago, you got arrested for driving without a license.
No.
No?
No.
I see Mom, but I'm not asking you, I'm asking him.
But I was arrested for a 2023 case that I had completed. That was when I was in school. I was rearrested because I guess however they do the court system in Clay County, they didn't never clear it because the plan, what the judge told me was I do the program and they expunge it off my record, but I guess they didn't never finish doing it. So when I got in the car accident with my mother, when the lady was writing the police report, she got my license and seen that everything that I had already did my stuff for it, I still had an active warrant, so I had to redo the process and repay the money, but I got everything back and everything has been cleared.
Okay. So the arrest that we heard about from February of this year was sort of a rearrest for something that happened a long time ago.
Yeah, 2023, but I was not driving. Okay. I was not driving or nothing. It was just
in February of this year. You weren't driving.
Never driving.
It just was for something in 23.
Yes.
Okay, that fits a little more because Ms. Smith-Man mentioned something about 23. Do you have anything different on that?
I do see the arrest from this. I also do see a similar case from 2023.
Okay. All right. Anything else?
No shit.
Okay. Well, Mr. Cobb, I find that there is a factual basis for your plea. You were driving this car super fast, it hit a tree, and there were tragic consequences. We had a case like this that went to trial not too long ago, that even older than this, and it was even worse outcome. It was friends who were, what'd you say? We got lit, they were goofing around, cement wall, 2 of them died. And the issue was a little different because they couldn't quite tell who the driver was. The accident was so bad and bodies were everywhere. So the big debate was who was driving. Here we don't have that struggle, but it's the same situation where they're all friends. So it's not someone's out to get someone else. It's just this question of recklessness and what are the consequences for that. So I do find a factual basis. I also find that your plea is knowing and voluntary, meaning you've understood what we've talked about. You've told me you don't have any questions, and it's voluntary. No one's forcing you to enter this plea. Is that a fair statement?
Yes, sir.
So I'll accept your plea. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
And Ms. Smith? And Mr. Cobb, is it okay if we sign the indictment for you indicating your guilty plea?
Yes, sir.
You want to be sentenced as a first offender. You qualify for that. You don't have any felony convictions. This is on the more serious end of things to get first offender. But if you are sincere in your commitment to making better choices going forward, first offender protects you in the sense that there'll be a sentence and there'll be consequences for this. But unlike Mr. Wilson's situation, they won't be forever consequences because at the end of your sentence, if you did well, it can all be sealed up and you can try to move forward in life. A first offender, that's the benefit, is that it can come off your record. The risk is that while you're under this sentence, if you mess up and get in new trouble for something, you'll have the new charges, but you also can have your first offender status taken away and you can be resentenced as if you pled guilty and we start all over again. So it could be a worse outcome than it is today. Do you understand how first offender works?
Yeah, I understand.
Do you want to be treated as a first offender?
Yes.
Okay. Well, I'll do that. So I'm talking to you, Mr. Cobb, but I hope Mr. Wilson's family is listening, and I know your mom and your grandmother are listening. This isn't about who picked up whom. It really isn't. It doesn't matter who started out driving. It's about who was driving those seconds leading up to impact. And that was you. It wasn't anyone else. It wasn't Mr. Newton. Clearly wasn't Mr. Wilson or the two other guys in the car. And so you all may have been doing kind of the same kind of things. And it's kids goofing off, but it was goofing off as if you were playing with a loaded gun. When you're driving 100 miles an hour, you might as well have been throwing a loaded gun at each other, and you hope it doesn't go off because it hits the ground and someone gets shot. You are not a professional race car driver, and your ability, none of the guys in the car, to figure out what to do when there's a sudden turn or there's a tree in your way going 120 something bad's going to happen. And I don't believe for a moment that you had it out for anyone in that car, because the way to get at someone is not to drive a car you're in into a tree. It would be to do something to them when they're not in the car or hit them with the car. So I don't think this was, your grandmother used the word ruthless or malicious. I don't think you wanted anything bad to happen to anyone, including yourself. But what you did was so dangerous and so reckless. It clearly had consequences for you. You were injured, but just hearing about the consequences for Darrell Wilson, and I don't know how Boss Newton is doing. I don't even have names for the other guys. It's this kind of situation where there are repercussions for those other consequences. And while I appreciate that since that time, you've done pretty well. There was an arrest for battery against a pregnant female. I don't need to hear about it. It's just an arrest. But by and large, we certainly haven't repeated this. You didn't get arrested again for speeding in a crazy way somewhere or getting into a wreck. But we can't erase this. This doesn't go away. And part of what we do when judges are thinking about what's the right sentence, you want to rehabilitate, and you've brought in resources that are all about rehabilitation. But there is sometimes a punishment aspect to sentencing because what happened was wrong and it had real serious consequences. And I have to weigh that as well, and deterrence to make sure nothing like this ever happens again. I think what you went through and what you've learned, I'm gonna call them your friends for purposes of this case. You knew these guys. What they've gone through hopefully would deter you from doing this again. But there's the reality of what Ms. Thompson and Mr. Wilson are having to work through and support for the rest of Darrell's life. And when I weigh all that, Mr. Cobb, I think that the right sentence in this case is an overall sentence of 7 years to serve 2 years with a balance on probation. It is a custodial portion that reflects the seriousness of what happened and the tragedy of what happened and the fact that punishment flows from making those kinds of decisions. I understand the recommendation of 5 years, but I also very much understand dumb things that 18-year-olds do. I have an 18-year-old son, and he is smart, like you're smart, but he's also dumb because he's 18, and he will make bad decisions. And you made going that fast with all those people in the car, who knows who was wearing a seatbelt and who wasn't, a tragically bad decision. And it has cost Darrell Wilson his ability to move about in life like every young man would like. You've still got all those freedoms. And once you serve your time and you'll be paroled, you have no criminal history, you'll gain all those freedoms back in a way that Darrell won't. If you want to have a family, if you be able to care for your mother and your grandmother, have a career, be a senior executive at Amazon, not just a guy doing customer fulfillment. Those are all the possibilities for you that were taken from Darrell because of the decision you made. So I'm just trying to explain to you the thinking behind what I'm doing. I am not deaf to the good things that people have said about you, and they're all true. You are more than what just happened today. And that's why you'll be able to be all those things when you're done with the custodial part of your sentence. You will then be on probation. It's a first offender sentence. The only special condition of probation that I'm imposing is that you need to have no contact with any of the people who were in the car or their families. So even though you may want to reach out to Mr. Wilson's family to say, hey, just want to see how Darrell's doing, that outreach would need to come from them. And if they want to check in, they could do that, but they're going to do their best to move forward, and you won't be a part of that. You have done well while you have been out on bond, and so I'm okay with a delayed reporting date. In other words, you don't have to go into custody right now. We'll give you an opportunity to talk with Ms. Rios about when you want to turn yourself in. It's here, you come back to court. It's not months from now. It would be in the next few weeks that you need to come back here. But I'm gonna let you and your family and Ms. Rios talk about that, and then you can let me know if you want to just get started today or if you want to have a reporting date. But know this, in case you get any thoughts about, well, I could use the delay reporting date as a way to get somewhere else. If you're not here on the date and time we agree on, then I will follow the state's recommendation and the sentence that I'm not actually signing any paperwork today. I sign the paperwork whenever you turn yourself in. So if you want to go in today, I'll sign it today. If we agree it's date X, then I'll sign that paperwork. But I'll actually have two different sentences. I'll have the 7 to do 2. I'll also have the 10 serve 5. And if you're not there on the day you're supposed to turn yourself in, I'll sign the 10 serve 5. You'll bite yourself 3 more years in prison. And eventually you're going to run a stop sign, you're going to get pulled over, and that warrant will be sitting there, and you'll need to deal with that. So I encourage you to be here on the day you need to be here, assuming you want a delayed turn-in. Did you and Mr. Cobb talk about that at all, Ms. Rios?
Not a turn-in date, yes. We'll go outside.
Okay, please do. One last thing. I didn't impose as a special condition participating in any programming, only because I'd want to give Mr. Cobb the opportunity to think through what's the best fit when he gets out. And that's a great program, and he'll still be of age to be in it. But that's a decision for family to make when he's finished up with the custodial portion. Okay. Before you go, do you have any questions about anything I've said about your sentence?
No, I understood everything you said.
Okay. Go chat with Ms. Rios and let me know.
Wow.
Is Mr. Clark in the courtroom?
2 years in prison.
Hey, Mr. Clark, if you could come on up to the podium. So, Ms. Niles gave me a summary of what you're trying to do and the situation we bumped into. In order for me to authorize you to not have to pay the filing fees, I need something more than just your say-so. And it's not me doubting you. It's just we're required to have documentation that you qualify. It's an EBT card, or it's something from the Department of Labor saying Mr. Clark hasn't worked the last 2 quarters, or because they would have a record if you were working.
Yeah, we're going to bail on this here. Wow. Not sure. You've got, I don't know if the judge understood what Daryl experiences now. He's nonverbal, meaning he cannot speak. He's hands curled up in fetal position all the time. Constant care required. Nurse 24/7. That's that was heavy. I think it was fair. He almost died too. I don't know. I don't think making a stupid decision and getting hurt by it means that you shouldn't be punished by the courts. I don't know. Wasn't intentional. Intentional is, did you mean to push your foot on the gas pedal? that's intentional. You don't get to choose to say the outcome wasn't intentional. And I dislike that the judge just let that stand. He knows exactly what the definition of intentional means. An intent can be formed in an instant before action was taken. He was in the car with them, though. He did it. He was the driver. It's a heavy hearing. Yeah, Sarah Boone's wasn't intentional either. I get frustrated when I get frustrated when I see kids trying to act out a Grand Theft Auto plot in real life. The fact that it works in a video game, and if it doesn't work, you can just hit a button and restart. It's bad training for real life, for sure. So, I hope he has turned around. I hope he does turn himself around, because there are some people who can't, who won't be able to just walk away from that. I think the judge did well. Yeah. He's a good judge. I do like him. All right. It's Thursday. We do not have a podcast tonight. Can we talk about the goose again? A burner phone number, 801-513-1160. That's the number to call to be connected. It's on the screen here now, where it should be. Why is it not working? Well, go figure. Let's see. Not this one. Did we break the burner? Commands, chat commands. Man, they've changed everything. I have to find it again. Where's burner? Amber says you may have a sponsor hookup. Let's jump to something maybe a little bit lighter. How about that? We can't end on this. We just can't. Here we go. Oh, we got a call coming in. Hello?
Call from Novia. To accept, press.
Is this Novia? Hello?
No, PNW.
Oh, PNW. Sorry, you said it so
hear me?
fast.
Yes.
Pacific Northwest. We gotcha.
Okay. Yes. Yeah.
What are your thoughts?
It came in at the last minute a little bit. But just crazy to me. My mom-in-law, she got into a wreck a few years ago. Her boyfriend at the time was actually driving the vehicle. They were going to OMAC, I want to say.
Okay.
Pretty spot, going through Grand Coulee and everything, and he was going real fast, and he ended up doing this turn really fast, and we don't really know exactly what happened, but he wrecked the vehicle, and he actually ended up rolling it and killing her.
Oh no!
But it makes me angry because it's like investigation or anything on that, so he never got charged or anything for it. So there was kind of no justice. But with this case, I feel like there should have been more. Because, that guy could have, he could have passed away. I only heard what you said about him. He's, kind of in a position where he can't really move around now. But, I don't know, it just kind of, my thought was I don't know, it's just kind of crazy sometimes how our justice system is, because people's lives are taken, half the time and then not investigated because of whatever reasons they have had. But it's just sad.
Yeah, I agree. I don't know, this one just frustrates me.
Right.
the attitude that's out there, and the fact that yes, one kid wrecked, but for this one wreck, there were probably 20 that didn't wreck, or it was only minor damage, and they were able to drive away from it, or nobody got hurt, or it sort of doesn't seem fair that everyone else is doing it and I'm the only one that got caught. I can see that attitude out there among kids and maybe even among some parents. But it shouldn't be like that at all. I mean, we've got to do a better job with our kids. They've got to value not just their life, but other people's lives more than they do. People aren't disposable. You're not disposable.
No.
And
car, I mean, you can fix a car or whatever, but you can't bring anybody back.
Yep, this one was a stolen car, so it was a bad decision on top of a bad decision.
Oh, okay.
Yeah.
Like I said, I came in late, so I didn't know much of anything, but yeah, that's horrible. And then the whole, intentional thing, I agree with you on that because, as you start to go fast, faster than what the speed limit, you know exactly what you're doing.
Yep.
You know that you're going faster than what that speed limit says, and anything can happen, and maybe it won't be you.
I wish
maybe
the judge
it could
would
be somebody else or
right. Correct. I wish the judge would have at least educated both the mom, the defendant's mom, and the defendant on what intentional means. And where intent is, because nobody intends to. Nobody goes out saying, how can I reach the worst possible outcome? Right? Nobody thinks about the outcome. But to be able to say, I didn't want this outcome, thus my actions were not intentional, it's a disconnect. You've got to understand that you don't get to choose the results. You make a choice up front, and then those results those are chosen for you. Your choice was when you made, the choice at the beginning before you got in the car, when you put it in drive, when you stepped on the gas, when you didn't stop, when you went faster. That's when you got to choose. It's after that you have no choice, and you can't say it wasn't intentional because now I don't like what happened as a result. So PNW.
So did they say how old he is now, or
He's
when
20.
this happened?
Happened 3 years ago.
He's 20 now.
Yeah. 2-3 years ago.
Oh my goodness. Okay, so yeah, in my opinion, I feel like he should be getting more time, just to kind of teach him a little bit. I feel like 2 years probably is not enough.
Yeah.
But I guess prison also could be, no matter how much time you're in there, it could be hard, and it's for a reason.
And our prison system doesn't necessarily fix people either. So if we're putting somebody in so they can learn their lesson, a lot of times we're breaking them further. And that's a whole different argument. But PNW, we're going to watch one more thing, a palate cleanser, hopefully, that will end our day on a little upbeat instead of this downer. So thank you for the call.
Let's do it. I appreciate talking to you. I'm always watching you while I'm working.
Thank you so much.
Appreciate it.
Thank you.
Have a good one.
Bye.
Bye.
All right, let's see if we can go to this one that Josh found, as long as it's still up and available. Give me a second here. 6, 7. No, 7. We want 7. Here we go. All right. Is it working? We're playing. Maybe. Is it paused? Looks like everyone's holding very still.
Assumed to be an appearance because number one, the court's ordered it to be in person, and it's my view that it's not up to the defendant to decide whether they want to appear in person or whether they want to sign in that video. And so I don't view it as an appearance. I view it as a failure to appear as ordered by the court. There's been multiple failures to appear. Mr. Eilber is he's charged with delivery of methamphetamine as a second or subsequent controlled substance offense as a habitual fourth offender. So we're looking at a life offense, a significant penalty here. So at this point, I think the court's
can't just show
justified in requesting a bench warrant. So Mr. Roll, I will ask that you do that. We will get it on the docket for trial. Mr. Rolla, how many days of trial do you believe this case would take?
Would be
Josh,
8
is the right one?
witnesses, 7 plus the lab personnel, Judge.
Okay.
So you'll probably take a full day, if not a little over 1 day.
All right. I'll set it for 2 days, Mr. Trush. Do you think that would be adequate time?
I'm sure that would be adequate.
I would actually have guessed probably 1 day.
Josh gave me this timestamp, and I think I got the wrong one.
And then I guess I would suggest
Josh,
to the
where are
court, a final status conference, maybe the month before, the same month. Obviously, I don't know that Mr. Albert is in Alpena's jail. I mean, it's certainly possible that he is. If he's in the jail there, you know, that may change his calculus in regards to this case, depending on what he's facing there. So I would just obviously ask for a final status conference. I'm somewhat loath to waste trial dates.
Okay. Yep, I would agree. So we'll set it for a 2-day trial at 60 to 90, well, let's say 90 days. The court will set it for a status conference, final status conference prior to the trial date. That'll be the plea and motion cutoff. And
this is Judge Mertz.
If Mr. Albert hasn't been arrested or doesn't appear at that final status conference, we can discuss what to do regarding the trial at that time. Any other matters we need to address in this file?
Just for housekeeping, the plea offer that was extended back on March 4th, 2026 remained open until the final status conference, Judge. And that was a plea of count 1 without enhancements.
Okay. All right. Thank you.
Just stick it in the milk crate right there.
Is Mr. Love going to be appearing in person, or is he lapsing?
No, he should be appearing in person.
Let's take a short recess.
There are people out here. Yeah.
Okay.
That is Mr. Love out there.
All right. So we'll take a short recess and then we'll come back on the record.
It's one where the whole video is 1 hour, 32 minutes, and 51 seconds. Okay, hold, please. Let's check this out. Okay, I've got the wrong video here. 1 hour. Oh, it's the other 526. So it's going to get better, guys. Hang on. And it's going to be, hang on, let me get the timestamp again. It is 36:44. Wait for it. Thank you, Josh. Appreciate it. I had the wrong video. Or the other video had the same name. All right. Here we go. Milk crate's still here.
Ms. Pulaski, are you able to hear me?
I am, Your Honor.
We're on the record in People versus Pulaski. This is file number 246716. The record should reflect Ms. Pulaski present today by Zoom video. This is a hearing on Ms. Pulaski's motion for early discharge from probation. Mr. Rowland, did you get a copy of that?
I got a copy of the motion that we received on April 17th.
Okay. What is the prosecutor's position?
There's a couple of things. For the record, my role have people. As an offer of proof, and I have witnesses here to that testify should be necessary. It would be the people's position that early discharge is not appropriate in this case for the following reasons. While Ms. Pulaski was on probation with the circuit court, and while the court granted her quote-unquote work release, end of quote, Ms. Pulaski was observed first on April 23rd, 2025 at the Myers here in Gaylord, purchasing beer and loading it into the back of her husband's pickup truck. And then again observed on May 17, 2025, doing the same similar actions again at Myers shopping and coming out. What makes it particularly harsh in this matter is her efforts and actions were specifically observed by family members of the decedent. And as to the latter date, the 5/17 incident, Ms. Pulaski recognized the people that were there, waved to them and said, hi. It's the people's position that she has taken absolutely no remorse for the death of the person she caused, and that she effectively has flaunted the system. I would further advise the court that after first being advised of the incident on April 23rd, my office, I know because I did it personally, contacted both probation and parole and then the work camp supervisor in regards to that incident, had it reported to them. I had Ms. Autumn Pappas, who is present here today and can testify as to that information, providing to them, as with the second incident, when I actually asked the work camp supervisor to consider revoking her work release privileges, because she obviously, as I understand it, shopping at Myers and buying beer and loading it to the back of a pickup truck is not a condition of work release. And again, it's a situation where this is a case that, quite frankly, early release should not be appropriate. Thank you, Your Honor.
All right, so Ms. Pulaski, under the court rule, which is MCR 6.441F, when a probationer is requesting discharge from probation early, the probationer has the burden of showing by a preponderance of the evidence, number one, that they're eligible for early probation discharge. In other words, that they've served at least half of their probation time. Number two, that they've achieved all the rehabilitation goals of probation, and that they are not a ongoing risk of harm that could only be mitigated with continued probation supervision. Were you aware of that rule and of your obligation here today to present evidence in support of that?
Yes, Your Honor.
Okay. What do you have to present as to those matters?
I have not broken probation. The work camp.
Hold on a second. Before you go further, is it just going to be your statements on the record today, or do you have any other evidence that you're going to be offering?
Sir, Your Honor, I don't understand what kind of evidence would I have. I mean, I don't really understand the question, I guess.
So again, under the court rules, it's your obligation to prove to the court by a preponderance of the evidence that I should allow you to be discharged. So it's not up to me to decide what evidence you should or shouldn't present. That's your obligation to present that to the court, and it's up to you to decide what you think you need to present in order to prove those things.
Your Honor, I have just my statement, and any questions. What Mr. Rolla said by family members is very untrue.
Hold on. So if you're just going to testify, then I need to place you under oath, because again, I need to take evidence. In order to do that, you have to be under oath. So can you raise your right hand, please?
Put the beer down.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you. You can lower your hand. Now, I'm going to allow you to testify, but I also want you to be aware that Mr. Rolla has the ability to cross-examine you, or in other words, to ask you questions as well. So I just want to make sure you're aware of that. So what is it that you would like? Okay, what is it that you would like to state by way of your testimony then?
I have not broken my probation. I have followed through with everything. All my court fees have been paid, all my fines. I have showed up appropriately when I'm supposed to. I have not bought beer. I did not load beer. There was an incident when I took and went for dinner at the rail side a couple of times, and I was okay by Keller and Dennis both knew, Koshoniak, both knew and gave me permission, as long as I sat at a table, did not have any alcohol in front of me, and it was very apparent. And I had what I was drinking was water or Verner's, and to make sure any empties, if anybody else had anything to drink, they were not by me. And Justin, also my probation officer, knew, and then they had said that the family was making accusations, and to just if I could not go to the restaurant, that would be preferable. So I stopped doing all of that. I never did anything that was illegal or like that would break my probation. I'm a law-abiding citizen, and I've never ever been in trouble before. I have grieved over the 2.5 years. I have never broken the law before. I have no trail of anything. I don't drive. I still panic when I'm in a vehicle with somebody driving, with any vehicles that might be coming out of a parking lot or anything like that. I need time to take and grieve properly And I am a good citizen. I volunteered at the fairgrounds, at the fair for over a week, paid camping, and I volunteered for many other things, and I just don't know and I don't understand why I was being harassed. I do not know the family. I have no idea what anybody of the family looks like except for when they went to court today. And I don't know what they look like.
Okay, all right, thank you. Is there anything further that you wanted to say today?
This has actually interfered with our business.
Buying and selling alcohol? What
I
is
respectfully don't go to the restaurants. I can't have any type of business meetings or any type of luncheons. I can't go to a lot of the family get-togethers because a lot of times they'll have dinner at a restaurant, which they also serve alcohol there. I am seeing a counselor. I'm going through occupational therapy. I'm going through eye therapy. I just had back surgery, and I have upcoming shoulder surgery from the accident. I'm doing everything and possibly I can. I'm a very kind human. You ask me to help you and I will. I hold doors open for people. I tell them please and thank you. That is not me to take and be a snub and take and be what Mr. Rolla said they said. I would never act like that, and I never did put beer in the back of the truck, and I never did buy it. I won't even go buy somebody in my family if they are buying alcohol. I won't even be by them because somebody wanting to accuse me of something that's not true.
Okay, all right, thank you. Mr. Rolla, did you have any questions for Ms. Pulaski?
And Ms. Pulaski, you understand you're under oath right now, correct?
Yes.
Isn't it true you were in fact at the Myers store here in Gaylord while on work release on April 23rd, 2025? Yes or no?
I don't know the date. I talked to Keller and we had the discussion and it was clarified.
That was after it happened, ma'am. Isn't that correct?
After the accident?
After you were observed being there.
Mr. Rolla, I'm sorry, I don't understand the question.
It's simple. Were you or were you not at Myers store here in Gaylord on April 23rd, 2025? It's a yes or no question.
April 23rd on 2025.
April 23rd, 2025. While you were on work release.
If I was on work release and I was on Myers, it had something to do with me having to pick something up for the business.
And were you also at Myers on May 17th, 2025 while on work release? Yes or no?
I don't know the date, sir, but I often go into Myers and I have to pick up stuff for the business because that's why I was out on work release, and I would let Keller know or I would let Kashoniak know.
Is picking up beer something necessary to operate your business?
I did not pick up beer, sir.
I have no further questions of this witness, Judge.
Okay, all right, thank you, Ms. Pulaski. Under the statute and the court rule, Mr. Rolla, the court also has to allow victims an opportunity to be heard. Did you wish to call anyone?
I do wish to call Ms. Autumn Quampas to the stand, Your Honor, regarding these very incidents.
Okay. And I can just have you come right to the podium there, please. Raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you state your first and last name and spell both for the record?
Autumn Quapis, AutumnKwapis.
Thank you, Mr. Rolla.
Thank you. Ms. Quampas, are you familiar with Regina Pulaski?
I am.
Would you recognize her if you saw her again?
Yes.
Is she present in the court here via video today?
Yes, she is.
Did you just hear her describe her incidents or non-incidents regarding April 23rd, 2025 and May 17th, 2025?
I did.
Do you have personal knowledge and information as to either of those incidents?
I do.
Starting with the April 23rd, 2025 incident, what did you observe and where did you observe it?
I was at the Gaylord Meyer when I saw her husband by the truck at first, and then she came walking out a little bit later with a cart full of groceries. And in the back of the vehicle, I saw a blue box that has the white label like Bud Light does. And they were loading groceries onto the back of this truck.
When you say they, who specifically are you referring to?
Regina and Daryl Pulaski.
And where were you in a position that you were able to see this?
I was in the back lot of the parking lot because I had carpooled with a fellow nursing student, and that's where we had met. And we were chit-chatting when I saw him, and I do have video evidence of this happening also.
Oh. Now you mentioned video evidence. What are you talking about?
I have video evidence of her walking out, loading stuff into the vehicle, and another video of her putting the cart back and a picture of them driving back towards their house afterwards.
And that was on April 23rd?
Yes.
And of the stuff that was being loaded into the back of the pickup truck, did it include any type of alcoholic beverage?
I did not start recording right at the beginning of when she did it. I did see the blue box there regardless, but there were multiple different drinks being.
Okay, I didn't ask you if you recorded, I asked you, did you observe that?
Oh, yes, I'm sorry, yes, yes.
And you said a blue and white box, which you believe to be containing what?
Beer. Bud
Light.
Or, yeah.
Bud.
Are you familiar with what Bud Light boxes look like?
The blue and white box, yeah.
Why is that?
Them.
What?
My husband drinks them.
And in regards to, as to this incident on April 23rd, after it occurred, did you take any steps to try and notify any agency or persons?
I had called you right away and I had sent you an email.
When you say you, who are the you referring to?
Mike Rolla.
Okay, the prosecutor's office.
Yes, sorry.
To report what?
The incidents of which I thought she wasn't supposed to be out.
And did you also become aware of a second incident on May 17, 2025?
I was.
Involving who, please?
My mother-in-law, Julie Quapis, and Earl Quapis had saw her in the store, and she had addressed them personally.
While Ms. Pulaski was doing what?
Grocery shopping at Meyer in Gaylord.
I don't believe any further questions of this witness, Chuck.
Okay, Ms. Pulaski, just like Mr. Rolla had a chance to ask you questions, do you have any questions for Ms. Quapis about what her testimony is?
Yes, I do. The reason I walked out of the store, I'm not saying that I didn't walk out of the store and I wasn't grocery shopping, because I'm not aware of what day this day is or that day. So when I come out of the store with groceries, I came out of the store with groceries. Regardless to what's going on, I normally don't ever load the groceries up if I'm with my husband, and I absolutely did not load any beer, and I wasn't with him when he bought beer. I mean, like, in line. That's why I came out separately, so it would be very well aware that I was not the one buying beer or consuming the beer. And the second incident, yes, I know Earl, and I know the Quapises. And yes, if I'm out grocery shopping and I see somebody that I've been friends with, there's no reason why I should not be able to say hi. I went to school with Julie. I worked with Earl at McDonald's. I don't understand where you're coming and presuming that I personally bought the beer and that I would be loading it on either occasion. I have not drank alcohol. Did you see me drink alcohol? Did you see me touch that alcohol?
This is a long question.
Ms. Quapis?
Okay, I'm sorry. I wasn't sure if I was allowed to.
Yeah.
I'm sorry. What was the question again?
Did you see her actually touching any alcohol or consuming any alcohol at that time?
I guess not at that time, no.
At any time, have you seen me while I've been on probation drinking alcohol or touching alcohol?
I think it's more so the fact that
Well, no,
being on,
just answer the question. Have you seen it personally?
not personally.
Okay. Is it illegal for my husband to take and buy beer or anybody in my family so that they can drink it? They are not on probation, right?
This Pulaski, that's not really a question this witness can answer. She can give us legal opinions. So.
Okay. So my question is I'm on probation. Does that make it where my family cannot have their
Pulaski, that's a legal question. That's not something
sorry.
Saw or heard.
Okay, I apologize. I didn't know how you wanted me to word it. I guess there's not a way to word it. I guess the thing is I'm on probation and my family's not, and they can do their American rights.
Okay, do you have any other questions about what Ms. Quapis saw or heard on either of those dates?
Okay, if you hear something, is that hearsay? Did you witness everything that was responded back to you, Mrs. Quapis?
Judge, this is a post-sentencing hearing for which the hearsay rule does not apply.
Yeah, and I believe Ms. Quapis was clear in what she saw and what was reported to her by the other individuals. So.
Well, that's why I was asking, Your Honor, about what that's hearsay that she heard from other people. I don't know the law. I apologize.
Okay. Do you have any other questions for her?
On any other occasion while I've been on probation, have you seen me break the law of my probation?
No.
And so you did not literally see me touch the beer that you thought I may have put in the back of my pickup.
She already testified to that. So.
Oh, okay. I'm sorry. So I believe that all my questions, sir, Your Honor, they are done.
All right. Thank you. We can step down as well. All right. Mr. Roll, I mean, just through argument, I think your position is that the court should not grant the relief requested.
Correct, Your Honor.
Okay. Ms. Pulaski, is there anything else that you want to say in support of your position today?
Yes, Your Honor. As I said before, I'm a law-abiding citizen. The accident with Mr. John Sharp was truly a tragedy. I carry that burden every day with me. I don't ever feel the hurt that the family must feel. I myself is very hurt from this. It's very mentally distressing, and I need time for healing myself. And I would never pay disrespect to the family. I would never smile and giggle. I do not know what they even look like. I feel like at that point in time when I was being asked about it, I was being stalked. And I still don't know what the family looks like. I'm not that type of person. I'm a kind-hearted, loving person.
Okay. All right, thank you. So again, the court refers to MCR 6.411, both E and F, as the court rule governing the proceedings today, as well as MCL 771.2. When a probationer petitions to be released from early discharge from probation, the court is required to hold a hearing. The court is required to allow the probationer to be heard and any victims to be heard. The court has conducted that hearing under, again, sub F and 771.2 sub 7. The court has to find by a preponderance of the evidence that the probationer has complied with subs 1, 2, and 3, which I indicated earlier. I think Ms. Pulaski is technically eligible for early release from probation. I did have a chance to review this file, although I remember this case very well because of the nature of the case. I remember the sentencing hearing very well. We had a lot of statements from all sides during the course of that sentencing hearing. Because of the nature of the offense in this case, involving the death of another individual, there are, I think, extra considerations that the court must consider outside of what it would typically consider in a case that doesn't involve a death of an individual, in particular with regard to the victims. Listening to the testimony, I don't think the court could find one way or the other that Ms. Pulaski violated her probation during the incidents alleged. I think the court would have to find that there was some evidence that she was actually possessing or consuming alcohol. I don't think there's enough evidence based on the testimony to make that finding. But I also don't think it's on the prosecution's, it's not their burden to show that you did violate your probation. Again, it's your burden, Ms. Pulaski, to show that you should be released early from probation. And based on your testimony here, which is simply that, you've complied with your probation, there haven't been any proceedings alleging any violations of probation. But under the court rule and the statute, I think it requires a showing over and above just that you've been in compliance. And I don't find that you've met your burden by a preponderance of the evidence here today, specifically that you've achieved all the rehabilitation goals of probation and that you would not present an ongoing risk of harm to the victims in this case, certainly not the ultimate victim, but the remaining family members. And for all those reasons, in the exercise of the court's discretion, I do not think it would be appropriate to discharge you early from your probation in this case, given all the circumstances and what the court's heard today. So the court is going to deny your motion. And Ms. Pulaski, you will remain subject to the conditions of your probation through the end of the term as sentenced by the court. And that concludes this hearing today. Ms. Pulaski, you are free to disconnect at this time.
Thank you, Your Honor.
Judge, do you want our office to prepare an order?
Yes, please. Thank you.
We'll do so for reasons as stated on the record.
Correct.
Thank you.
I think this courtroom could really do a lot better, like visually, if they got rid of the milk crate, got rid of the garbage can, maybe that whole tray with the hand wipes and everything else. Just put that somewhere else. They'd do a lot better. But there we go. No more please and thank you. We're going to be done. We're going to be done for today. Probation is BS. Yeah. She volunteered at the fairgrounds. She holds the door for people. She doesn't load her own groceries, though. You heard that. And the whole here's a problem I had with her. Ready? She's all pretending like she doesn't know what they're talking about at the Myers. And then when they hear that's on video, when she hears it's on video, they've got a video of that. She's like, the reason I had my husband buy the beer separate was, it's like, just own it up front. Just say my husband buys beer, but I don't. I bought groceries, he bought beer. It's legal. Didn't drink any. It's fine. It's all. No podcast tonight. That's going to be tomorrow. Weather Watch is out on a business trip. He'll be back tomorrow. So. Yeah, JR, I didn't get into that part. Tomorrow's Friday. It's great. We're going to see if we can get some new courts starting on Monday. We'll keep an eye out for that. If you guys see something coming up that you think we should follow, give us a little buzz on the burner phone. Let us see if we can follow it and get it in as media. So tomorrow is Tree Case Friday. We need some tree cases. That's what we need. We need some civil stuff. Watch, Josh, I'm going to assign you on the civil tree watch. We need to find some civil tree cases. Thanks for no weird dreams as always. You're welcome. Good night. Don't forget to hold the door. Thank you, Purple Coconut, and volunteer at the state fair. Got to do all those things. All right. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe. We'll go live again tomorrow morning, about 9:30ish. It's Friday after all. And then we'll have a podcast tomorrow night. So, sounds good. It was a fast week, Mary. It was a fast week. All she received for punishment was probation. Yes, and her car accident was probably also intentional, and it caused fatality. Different states, different results, different ages. All right. You guys are amazing. Be good to each other. We'll see you in the morning. The Foliage Friday. Yes. Foliage. We'll see you guys. Bye. That's not it. Greeners, that's not it. Hang on 1 second. That's not our exit symbol. Wait for it.